Okay, good morning. We are prepared to now start our East Point HOA Boot Camp. I cannot express how excited I am for this to finally come to fruition. And we wanted to be in person today, but of course, the COVID numbers are still surging at a number that we felt was a bit too risky. And Commissioner Arrington made that call, and we appreciate that so much. But we will be back in a more in an in-person format when we have the opportunity to do so. So I'll start off just introducing the HOA Alliance coordinators, and they are our very own Commissioner Marvin Arrington and Mr. Carell Driscoll. And I'd like to also thank the entire team, Ms. Channing Parham and Jarrell Sharon and others, as well as our very own East Point City staff members who are with us today. We have a very informative agenda today, and I think that everyone will be very pleased with the information. There will be plenty of opportunity for Q&A, and we will definitely try to cover as much as we can in getting those responses to you. And I'll make a promise that if we cannot get your question heard today, that we will take those down and be able to reach out to you with those responses properly. Our agenda today will cover 4 topics primarily, and they include, our first topic will be short-term rentals. And I know that's a very popular topic here in East Point. The second topic will be covenant violations versus code enforcement. And that's very critical because there are certainly differences in which, you know, the HOAs or the communities are able to enforce violations versus that of the city code enforcement. We will have a keynote speaker today during the lunchtime hour, which will be Mr. Justin Miller-Dubose from Allstate, the Marshall Agency. And then after that, we will have a topic entitled legalities of HOAs, COAs, and POAs, presented by our very own Mr. Commissioner Marvin Arrington, as well as finishing out with best practices for transitions of HOAs. So we look forward to this being a very informative format. And so I will now yield over to Commissioner Arrington for opening remarks, as well as getting our agenda started off.
Thank you, Councilwoman Gordon. It's a pleasure to be here today. Thank you for inviting us to bring this information to the East Point residents. We're very excited to be able to do this, and we also look forward to being able to do this in person in the future. My name is Marvin Arrington Jr. I'm one of the founders of the HOA Alliance, along with Mr. Carell Driscoll. And we are homeowners just like you. And we found ourselves in a place where we didn't agree with the direction our HOA was going. It was being run by a management company who really didn't care about the homeowners and the community spirit. And so we wound up running, Mr. Driscoll and I wound up running for our HOA board and wound up with, becoming members of the board, Mr. Driscoll being president and I being vice president. And in the first 6 months, we were able to save $100,000 and put that into a reserve account. We had the management company and the lawyers. They had spent, I think, $3,000 or $4,000 trying to collect $70 from a lady that was in bankruptcy that no longer lived in the community. And so we were able to just wrap our hands around the numbers and everything that was going on. It doesn't make sense to pay $4,000 to collect $100 or $70. So we were able to put a stop to that. And again, we were able to save $100,000 for our reserve account within the first 6 months of taking over our HOA. And so one of the things that we found were the problems or some of the challenges that we were having in our HOA, the answers were down the street or in the subdivision next door. And we actually used the Nextdoor app. I don't know how many of you are familiar with that, but we used the Nextdoor app to help get answers to our questions. And so as a result, we wound up starting a nonprofit, the HOA Alliance, that helps educate homeowners on best practices. We believe if everyone is educated about the rules of HOAs, then they will, the HOAs will run more efficiently. In the state of Georgia, there are over 2 million Georgians residing in over 10,000 different communities, HOA communities. And if you're familiar with your HOA and the declaration and the covenants, all 10,000 of those HOAs in the state of Georgia have different sets of rules. And so you can imagine it's pretty difficult for people to know what the rules are and know what to expect. So again, we started it. We're homeowners helping homeowners. HOA Alliance, please visit our website at hoaalliance.org. Please consider getting a membership so that you can either be of help to other homeowners or receive help yourself. Thank you. I'll turn it over to Mr. Driscoll.
Commissioner Arrington, I think you said it all for me. Again, my name is Carell Driscoll. I have enjoyed learning many of the lessons from many of the talent that we've had on the HOA Alliance, and I've also added value. And I look forward to meeting each and every one of you all. And please take time to enjoy the information and reach out to us if you have any type of follow-up questions. Thank you.
Councilwoman Gordon, if I can just briefly, just let people know this is our 8th year doing HOA boot camp, and we've hosted them in Fulton County and various counties around the state. And every year in November, we host our Georgia HOA boot camp where we try to bring everyone under one roof. So we hope that you all will join us at least for our Georgia HOA boot camp in November. If not for any of our other upcoming events in the surrounding metropolitan area counties. Thank you.
Thank you so much, Commissioner Arrington, as well as Mr. Driscoll, for being here again to provide this boot camp for us. We are excited. If I may, I would like to allow us to go ahead and venture into our first topic of the morning, short-term rentals. And one thing that I like about this boot camp is that Commissioner Arrington and Mr. Driscoll insisted upon allowing us to make it not just generally informative, specific to our own city's needs. And as many of you know, short-term rentals has been a very popular topic for a number of years from the beginning of my first term in office back in 2016. And we have, just as of last year, passed an ordinance. And this morning we have our community and planning, our planning and community development director, Ms. Kimberly Smith, with us, I believe. And I will yield to her to basically just reiterate what that new ordinance states. She will explain some of the zoning and how, those zoning designations apply to where short-term rentals are allowable and where they are not. In addition to that, we have recently approved a, I think we need to mute all. We have a management company that will be working with the city staff to assist us with enforcement of some of the guidelines and procedures. So at this time, I'll yield to Director Kimberly Smith.
Thank you, Councilwoman Gordon, and good morning to all. Thank you for asking us to come and talk about the City of East Point's new short-term rental ordinances. If I'm able to share my screen, I will do so now, where everyone could follow along in the ordinances and policies that the City of East Point have put in place. And I'm trying to share. I'm not sure who's in control, but I'm going to go ahead and move forward. And unfortunately, I'm not able to share my screen at this time.
I'm going to share, allow shareable options for you. Can you share now?
Okay.
Okay.
Yes, I can. Thank you so much. So, as stated previously, the city of East Point, we have several ordinances that were enacted in place in late 2020. There were 3 ordinances in reference to our short-term rental policies for the city of East Point. The first one was under Ordinance Number 159-020, and this was adopted in October of 2020, and it basically states the business licensing portion and the licenses portion when it's held outside of the zoning ordinance, but it's actually in the city's code of ordinances in the business license section, which basically defines and provides for conditions and definitions. We have 2 different categories of short-term rentals. The first one is called whole house lodging, and the second one is called homestay lodging. And the second and third ordinances would explain a little bit more of which is which as far as the 2 designations that were established in our business license ordinances. Going on to the second ordinance, which is found under Ordinance Number 150-020 in the city zoning code, it was actually adopted in December of 2020, and it is part of the city zoning code and development regulations. And what it provided for was for definitions, it provided for zoning text amendments, as well as district classifications, and it set boundaries to establish the homestay lodging. And where you can place or have or apply for homestay lodging in the city of East Point are the following zoning districts. And mostly it's in our residential zoning districts, and these are agriculture, single family residential. We have a residential limited zoning district, which is some of our larger single family residential lots. We have a zoning district called R1A, which is our urban residential, which allows for single family residences as well. You also can have duplexes under the R1A zoning district, but you have to do that with special permission and an administrative approval. Our R2 and R3 zoning districts are our multifamily zoning districts, duplexes, quadplexes, or what have you. And then R4 is for apartments and anything over 4 units. Our RT are for our residential townhomes. And then we have a CR, which is a commercial, a mixed use type of zoning district. And we have a CUP, which is a community unit plan type of zoning district. And then of course our institutionals, our medical institutional, and then our mixed use. So the homestay is the classification, one of the 2 classifications that would allow for a homeowner to apply for a short-term rental in their home, but they would actually have to stay there. They have to be there the entire time. So that's the definition or a description of what the homestay is. Our third ordinance and a second short-term rental designation is known as our Ordinance Number 149-020, and it was adopted at the same time as our homestay, but its designation is called whole house. And what that means is implied in the term whole house is you would be allowed to rent out the whole house under short-term rental designation. And those designations under our zoning districts are allowed in a far few number of zoning districts, which is our R1A, which is our duplexes, quadplexes, our multifamilies, and our mixed-use zoning districts. And with the whole house, they would be allowed, if you are a homeowner in one of those zoning districts, you would be allowed to apply for our business licensing through the first ordinance that I spoke of, which is in our business license ordinance. There is a application. There is, you have to pay fees. There are criteria that you have to provide to our department in order for you to apply. It's not just something that you can, if you have the zoning district, then you could say, okay, I'm just going to start renting to anybody. You have to go through the proper approval process and actually be provided with an approved permit through the Planning and Community Development Department. Also, I want to touch on we have the fees, we have the application process, we have all of the approvals in place, but the city of East Point also decided to hire on a third-party code enforcement component and felt that that was going to be very, very important to us being successful with the set of ordinances that were put in place in late 2020. So with that, we have just hired on the company Granicus. They have a lot of experience with all the different types of short-term rentals companies. And so they are going to be working with us very shortly. We're just getting a timeline together and coordinating with their team on how they're going to help us with the code enforcement component to make sure that we all are staying in compliance with these new rules that were just adopted at the end of 2020. And just a factual note, to date, I believe we have 3 applications in place. We haven't received that many, but we do have 3 applications that have come through, and we may have 1 permit that we have actually issued. So I think that the regulations may have worked well for us so far to date. And if anyone have any questions, I'll take those.
Okay, I'm looking in both the chat and I don't see any hands raised. If I am overlooking that, please feel free to bring that to my attention. Intermittently, though, I would like to say I appreciate you, Director Smith, for bringing the East Point perspective to this conversation. I do see a question from Mr. Tom Wardlow. He wants to know, how does an owner become approved for an Airbnb, or perhaps in this case, we want to say short-term rental because there are multiple companies, but of course, Airbnb is what we're most familiar with. So that question might be more specific to Airbnb, or Mr. Wardlow, if you would like to unmute yourself, you please feel free to raise your question. I'm not getting anything from him.
Well, I can jump in.
He's saying he doesn't know how to unmute. Let's see if I can unmute for him.
Okay.
Smith, go ahead and jump in while we're trying to figure out how to unmute him.
Yeah. Director Smith, if you had any other, well, there's another question. We'll come back to Mr. Wardlow. It's where do you go to apply for the homestay permit?
So on the City of East Point's website, we actually have an application in place that's been in place for a while now. And you would simply click on the application because all of our permitting is done online. It provides for you to set up an account where you simply can upload the application to our online permitting portal, provide all of the requested documents, because there is a lot of documents that you would have to provide for support that we would review, and basically just submit online, and then it would come to us. We would route it around to the different reviewers that would need to review it, and then based on the completeness of the application, we would make a determination whether you qualify to be a short-term rental permit holder.
Thank you very much. Another question, what was the name of the business or third party regarding code enforcement? And I think that was Granicus is what she's referring to.
Yes, that's correct.
Granicus. And just so I would like to say this, we did have public participation in this process. I know that some people think that this is unfair, And I do want to say that one thing that we did make clear, my colleagues, mayor and council, we did say that, this is all editable. We don't know as time goes on what the needs will become. But we had to start somewhere because we received a number of complaints. A lot of them were nuisance related. And of course, there are laws on the books to address nuisances, but there were also concerns about, this is a business, and how do we address that in terms of taxation and a number of other concerns. So we did have a number of public engagement opportunities, and that's how we decided to come together and draft this particular ordinance and pass this ordinance. But again, we are looking forward to determining how this will work in our city. And if changes are needed, we are definitely open to that and always want to encourage residents to come forward and let us know what your concerns are, and so that we can maybe have a broader discussion amongst mayor and council and with the community in the event that changes need to be made. So I want to just definitely be sure to let everyone know that. There was a letter, I think Director Smith might have mentioned, that was sent out, because one thing we also discussed in a meeting was that, with all these changes, we certainly did not want folks to be blindsided and not be aware of what's taking place. So a letter was sent out, and if you have not seen that, Director Smith, do we have that?
Yes.
Okay.
Yes.
Live, they can see you live.
This
Check
flyer,
your email. You gotta.
the flyer that was posted previously was actually the flyer that was presented to all of the homeowners in the city of East Point that receive a utility bill. It was placed in the utility bill. It was placed in a utility bill. If it hasn't been in there yet, it's going to be replaced in a utility bill. I would have to touch base with our communications officer, but this flyer here is actually what's going to be presented, announcing what has happened, the time frame, and everything of that sort. So this is the flyer that everyone should have received. It should be on our website as well. So we also did a letter, and I can share that as well.
I see the host has unmuted me. This is Tom Wardlow.
Okay, Mr. Wardlow.
Good afternoon.
Hello.
Morning, excuse me. So I'm not sure what you wanted me to respond to.
Your question was, how does someone, I think you mentioned become a host for Airbnb, or did you mean Airbnb or get licensing in the city to even have permissions to?
Yes,
to do
thank
this?
you. My question really is, how can I, as a resident, find out which houses are these? I guess I'm looking for whole house lodging permitting. That is, which houses are Airbnb or whatever other organization sponsored the whole house being a lodging for rent. Temporary, that is. Is there a published list of whole house lodging approved addresses?
To answer that question, the answer is no. With the city of East Point, because these ordinances were just enacted in late 2020, no one would have had the opportunity to be placed on a list. Each homeowner, if it is their wish, they would have to go through the proper approval process through our application, which is submitted through our online permitting portal. So at the current time, we do not have a listing of published homeowners that have been approved for short-term rental.
Thank you, Ms. Smith. I appreciate your answer. Do you anticipate that there ever will be such a list for our residents to see?
Was that a question for, I'm sorry.
Yes.
Was that a question for me?
Yes, please, Ms. Smith.
Well,
there is no. Go ahead.
Yes, sir. There is no list at the current time, and to be quite frank, we haven't thought that maybe we would publish them. That's something that we definitely can take into consideration moving forward. But as stated previously, we haven't had very many applications come through. I think the number is at 3 to date. So that would be a very short list if we did publish it. But that is certainly something that we can take into account if that's something that the mayor and council, the council takes into consideration, and if that's something that they would like to do, or our city management team. That's something that I would take up with them.
So if,
Yes.
excuse me, again, if a residence is being used as if it were approved for whole house lodging, there's no way to track whether in fact it has been approved by
Well,
the city.
currently that could be the case, but as I mentioned, we are in contract with a company called Granicus, which is going to act as our third-party enforcement arm, and they will provide us with tools and applications and account for any violators of these ordinances that were enacted in late 2020. So we do have a third-party enforcement arm that is going to act to help us with that list that you're speaking of. If there are short-term rentals posing as permitted home-term rentals, we will find those shortly, and that's the intent for them to notify us of those, and they're going to act as our enforcement arm to help us kind of I guess get those out of the way where we're not having a whole bunch of violators in the city.
Ms. Smith, thank you for your response. I truly appreciate it.
You're welcome.
Okay, thank you. And Director Smith, I have one other question. I know the answer would be no, but I'm going to ask it. Do short-term rentals change the zoning use of the property?
Short-term rentals do not change the use of the property. Short-term rentals, because we do have an application process, we are giving everybody the equal opportunity to apply for short-term rental. So no, it does not change the use, and we are affording everyone the equal opportunity to apply. And if they do submit and provide all of the appropriate documentation as stated in our ordinances, then they will be provided with a permit. If they do not, then they will not be provided with a permit. So it still maintains single-family housing. It still will maintain their duplex zoning designation. It wouldn't change the use.
Okay, thank you. And so I'll just ask a final round if there are any additional questions. If anyone has any additional questions, so please feel free to raise your hand. Mr. Warlow's hand is raised again, I believe.
Is there any enforcement involved in people who should be but have not acquired proper permitting for these whole house lodging?
Yes, sir. We have a third-party contract with a company called Granicus, and they are going to be acting as our enforcement for the city. They're going to let us know who's not in compliance. They're going to be sending out letters notifying violators of the ordinance violations if they happen to be in violation. They are going to be most likely put into code enforcement and have to go to court. So we do have an enforcement arm in place that we are just getting started.
Thank you.
Yes, again, thank you for that helpful comment.
Mr. Eric Coleman has asked a similar question, and he's basically wanting to know how soon will this ordinance be enforced? Granicus is just kind of coming on board, so again, nuisance complaints can be addressed immediately by calling the police. But I'll yield to you, Director Smith, as well.
That is exactly right, Councilwoman Gordon. Granicus is just coming on board. We are going to have a series of meetings with all of the departments that will be involved, which of course is our code enforcement department and any other departments, solid waste that may be involved. But we're going to have a team of short-term rental committee within the city intergovernmental coordination. And very, very soon, Granicus will be helping us maintain and enforce our ordinance. So it's in motion at the current time, and so I would say the next couple of weeks, we will be seeing the enforcement from our third party entity that has been hired to address that issue.
Thank you so much. And seeing no other questions, I would like to now yield the floor to our commissioner and Mr. Driscoll regarding this particular topic.
Okay, thanks. I think we have a PowerPoint. It was interesting to hear Director Smith that short-term rentals do not change the zoning. I think I have heard at least arguments before that, particularly if you consider the homestay, right? The homestay is, all right, you got to be there, and then someone else is there. So to me, that doesn't sound like single family. And I think that the argument at least has been made that perhaps they should be taxed more like a motel hotel. But I guess it's different everywhere. And obviously the city of East Point has made these ordinances in order to allow short-term rentals.
Yes, sir. Yes, the city has done that. And also, I just wanted to state, since you mentioned taxation, the third party entity will be helping us enact with the taxation component as well. And I just wanted to state that.
So one of the things that the interplay between HOAs, and I'm not sure if the ordinance addresses this or not, but just because you've been approved by the city for Airbnb doesn't mean that you have permission from your HOA in order to do Airbnb. And the Airbnb, to the extent that the HOA considers that this is not a single family use, you could potentially be in compliance with the city, but not in compliance with your HOA's declaration of protective covenants.
I'm glad you spoke to it because that was my concern, because even in my own community, I've seen our board try to address the challenges with short-term rentals by trying to get us to convert from an HOA to a POA to minimize the number of rentals in our community. So I guess this goes back to saying that this would be a great time for a collaboration between those formalized community associations and the cities. Thank you, Director Smith, for sharing the information. And I sent you a message about sharing that code so we can try to encourage other cities to follow in you all's footsteps. But Marvin brought up a valid question. And as you all may know, the city doesn't really, if I can say, have a say as it pertains to enforcement of the covenants within those communities. That's another challenge that we may have to take to a larger scale to have those discussions. Thank you for sharing that information. And Commissioner Gordon, thank you for providing us with the opportunity to share this information.
Thank you. And before Commissioner goes into his presentation, I want to thank him for bringing that point up. It did come up during the process of approving the ordinance, and the city attorney did confirm that HOA covenants do supersede the city ordinance when it comes to this. That is absolutely correct. So, and I will give you an example. Lakeside Preserve, I believe, or if it may even be my own community at Heritage Park. If the covenant states that those are not allowable, then they just simply are not. So the community covenant would supersede the city's ordinance here in terms of allowability. So thank you, Commissioner.
Yes, no problem. It's important for people to know that, just because they get approval from the city, they may also want to consider seeking approval from their HOA. I'm going to try to run through these slides real quick. I know we don't have a lot of time, but Channing, if you could go to the next slide, please. basically, what is a short-term rental? Typically, what we see Airbnb, VRBO, is 24, 48 hours, or, sometime less than a week. Could be less than 6 months, or, less than a year. Next slide, please. Community association, typically you have HOAs, COAs, which is a condominium association, and a POA, which is the property owners association. Those are all community associations. Community associations are typically subject to a declaration of protective covenants. The declaration of protective covenants basically is a set of rules and restrictions for which everyone on the land has agreed to abide by. If you purchase with inside a community association, you are automatically bound to the rules and restrictions that have been placed upon that land. Next slide, please. Single family residences, most declarations state that the homes are for single family use only. And they may in fact have a limit on rentals, and they may have rules for rentals. So you may have to apply to rent in your HOA. And so you may want to look at that as well. Again, check with your HOA before you start doing short-term rentals to make sure that you are in compliance. Next slide, please. Why do HOAs prohibit short-term rentals? And then even why is the city, looking at these? Because again, HOA, the Declaration of Protective Covenants, imposes restrictions on the use of the properties. With short-term rentals, the purpose is generally to protect other members. What we've seen sometimes are these party houses. So there'll be an Airbnb house that'll be rented out as a big party house, and there will be a lot of traffic and waste left for the community to deal with. Vacation renters typically tend to be a little messier and a little noisier than permanent residents. And again, like I say, short-term rentals can increase the neighborhood's traffic and parking problems. So that is why you see cities like East Point and HOAs looking to impose rules on short-term rentals, because this is something new that has come about. And so, next slide, please. The HOA has the authority to restrict short-term rentals. In the declaration, the board has the authority to do any and everything that they believe that they need to do in order to protect the HOA. The reason the declaration, as Councilwoman Gordon stated, the reason that the declaration and the rules in the HOA still must be followed is because the declaration is a contract between the homeowner and the association. And you jointly agree to accept certain obligations and restrictions on how the properties can be used. Courts generally assume HOA restrictions are enforceable as long as the restriction promotes a legitimate purpose and is not forbidden by statute. Even broader restrictions against all rentals have been upheld in some jurisdictions. So the starting point is to look at your declaration. If the declaration prohibits rentals short-term or long, or it says that no leases are under a year, then the HOA can likely enforce that prohibition unless there's some other reason that they won't be able to. Next slide. Those state HOA laws can vary from state to state. We see, certainly glad to see East Point taking the lead and putting in. I see the city of Atlanta has done something similar, and I imagine that most other cities will be doing so. In general, state law limitations on rental restrictions do not say that rental restrictions are completely unenforceable. In Arizona, for example, an HOA cannot enforce a rental restriction against an owner unless the restriction was already in the community's declaration when the owner acquired title to the property. And then in California, the law gives potential purchasers of homes in HOA communities the right to receive a written statement of any rental restrictions in a community before title to a property is transferred. And so a lot of the case law for community associations comes from California, Arizona, and Florida because they have a lot of condos and community associations. Next slide, please. There are contractual and statutory protections. I mean, basically what you have to look at here is you have individual rights, you have property rights, you have rights as an owner at your property. And so, you're looking at the difference between individual rights and the group rights. And when you sign on to live in a community association, you give up some of your individual rights for the greater rights of the larger group. And so that's what we always have to help remind homeowners. Yes, it is your house. Yes, it is your property, and you have all your rights, but you have given up some of them in order to, for the greater good of the group. Sometimes there are grandfather statutes that are relating to rental restrictions. I had one HOA that the declaration only allowed for 4 rentals. It only allowed 4 units to be able to rent. And it was just crazy because no one else had an opportunity to rent. Only those 4 units could rent, but there was a rental restriction. It was there, it was in place. And so, you have to, again, look at your declaration to see if there are any limits, rules, or restrictions in your declaration as to rentals. Next slide, please. Residential use versus commercial use. Someone could be doing the Airbnb and they're renting it out for a video shoot, or they're renting their Airbnb in the house because they're cooking dinner and having 100 people over and charging them for the dinner. So you never know what the different uses are, but residential restrictions have constantly and consistently been upheld by the courts throughout the country. And there's some other cases and state laws mentioned here. Michigan HOA with commercial use restriction could adopt and enforce a policy against short-term rentals, even if the HOA did not have an express rental restriction in its declaration. So just because the declaration doesn't have something, there may be rules adopted by the board. So there may be in addition to your declaration of protective covenants, there may be, again, a set of rules that the board has adopted, that the association has adopted, and you may be subject to those rules as well. On the other hand, states afford greater deference to individual homeowners' property rights. And for example, in North Carolina, courts typically interpret unclear restrictions in favor of homeowners. And so this thing is kind of all over the board from state to state. And so again, because this is a new topic. Next slide, please. And Councilwoman Gordon, let me know when we're out of time because I can stop early. But next slide is about adopting and enforcing short-term rental restrictions. You know, the HOA can't just decide one day, or, you know, if you're renting out, if you have a home and you've been doing Airbnb, and then the HOA says, hey, you can't do Airbnb, you know, they have to follow the process. They have to have a meeting. It has to be an item on the agenda, has to be approved by a majority of the board members. They have to adopt a policy and a procedure, you know, in order to have rules that govern short-term rentals or really any rentals, even if it's a long-term rental. You know, and you may want to amend the declaration if the declaration doesn't allow. Now, amending the declaration is a tall task. You need typically 2/3 of all homeowners, sometimes 2/3 of all lot owners, in order to make an amendment to the declaration, which is why a lot of times you will see boards just adopting rules, but the board cannot adopt a rule that is in opposition to anything in the declaration. So the declaration says no rentals under a year. The board can adopt a rule to do short-term rentals because the declaration is what everyone is bound by, and is what is the contract, again, between the homeowner and the association. In many jurisdictions, courts have found that an association that attempts to enforce a restriction that it has not previously enforced consistently or enforced against some owners but not others has effectively abandoned or waived its right to enforce the restriction. So the association has to keep up if they're going to enforce restrictions on rentals. They have to do it uniformly to every homeowner, and you know, they have to enforce it consistently. And so, but again, it's one of those things you don't really want to find yourself in court. So it's better to get permission and make sure that you and your HOA are on the same page. And I don't know how much time we have left, but I guess I'll leave some time. We can maybe look at some questions now.
Absolutely. If anyone has any questions, please feel free to either raise them in the chat or raise your hand and unmute so that you can voice your concerns. And as we wait for those questions, I do have a question, Commissioner Arrington. One of the things regarding occupancy, the length of occupancy that was concerning, and I raised it and it's in our ordinance, is that I know, just being the real estate part of me, when someone is, you know, in your home, even without a lease, if it's more than 30 days, they are considered a tenant and you may have to evict them out. So in our ordinance, we state less than 29 days per stay. So how does that play into, or have you seen any conflicts arise out of folks staying longer than 29 days with having to maybe evict someone out of a short-term rental?
I think you are correct in that if someone stays somewhere for more than 30 days, they can become a tenant. I have not seen a lot of that with the short-term rentals. Most of the short-term rentals, you know, will be for 2 or 3 days, maybe 7 days at most. I know, I guess that there's some that are, you know, are available for a month, but I think that, you know, most people, 90% or more, are probably using it for, you know, 3 to 7 days. And so I have not seen a lot with that, but you're right, there could be a tenant. And I think, you know, again, the whole use thing, and does the declaration say single family home, and is it really a single family home, particularly if you have the homestay option. I think that challenges the definition of single family use.
If If I can add some context here, Attorney Arrington, in many of the declarations that I have read for some of these communities, they usually specify what's considered to be appropriate terms used for renting out a property. Some would say they have to stay for at least 30 days. Some would say 6 months, 12 months in that declaration. So going back to an earlier point that you made, although they may get a permit from the city, they need to make sure that they either have legal representation to help them to peruse those documents and identify the requirements, or they need to personally wrap their heads around those requirements before they attempt to rent out their property as a short term or even as a rental. And I just wanted to make sure I make that point. The other point I wanted to make is, if I may add some value to my understanding of your point about changing the rules appropriately for a community association with the 2/3 vote. And this may be my misinterpretation of it, but you can help add value here. I was under the impression that although they may get that 2/3 to change the language of the declaration for renting out the property, if it's a further restriction, all homeowners have to submit to that restriction, or it doesn't. It's not applied to them unless they submit to it. So maybe you can add some value there.
Well, again, I think the courts are coming down on that in different ways around the country. So I think it depends on where you are, what city, what state. Are there a lot of vacation rentals there, right? A lot of places, I mean, if you're looking at, somewhere like Myrtle Beach or Hilton Head, they probably have a lot of vacation rentals. They probably have a thriving, long history of short-term rentals. But those short-term rentals are probably being used or not being used in a fashion like the way we've seen some here in Atlanta as big party houses, right? There's still, families going in for the weekend. And so, again, I think it depends on where you are and what the temperature is in your city or state for that. But I think you're right. Again, you're going back to real estate rights, and you're saying, "Hey, I have this right unless I give it up." Mm-hmm. So I believe that you are right. That even if 2/3 of the homeowners amended the declaration to allow for short-term rentals or restrict short-term rentals, that the individual homeowners who did not vote, the 1/3 of homeowners that did not vote for such restrictions, certainly have a good argument that those restrictions do not apply to their home. I think, whether it's a winning argument or not, I think, again, depends on, what city, state, and what is the temperature in that area for the rentals.
Thank you. I just wanted to bring it to the attention of the listeners because, this is, there's this fundamental aspect of being a community association member. If you ever feel like you're wrong by your community association, you have to litigate. And I wish there was a better way to resolve that.
Well, there are always alternative dispute resolution. There's mediation. There's arbitration, which are, similar to litigating in court, but are a little less formal and intimidating. And we need to have more HOAs and homeowners take advantage of alternative dispute resolution and mediation as a way. In fact, I think we really need a court in Georgia. I think we need a community association court. We have workers' comp court because we don't want employees suing employers. In my mind, we don't want neighbors within the same community suing neighbors. And so I think we should have a community association court that deals with these issues, because a lot of times you'll see someone facing foreclosure from the HOA because of a small, $800, maybe $1,200 bill that now has $5,000 in legal fees and $1,000 in interest and $1,000 in late fees applied. And so someone goes from owing $1,200 to owing, $8,000, $10,000. And so I think we need to have a better way to resolve this. I think there's a better way that we can protect Georgia homeowners from losing their homes to their HOA, and frankly to these management companies and law firms that have hijacked the HOAs.
Yep, and there's someone who posed a question about, do we have other states that have courts dedicated to community association to resolve those differences?
Not that I'm aware of, but I think that, that is where it's going. We actually have a law that we've proposed to the Georgia State Legislature, to the Community Association Protection and Transparency Act. We think there are just some basic things and basic rules that people need to abide by. And, I guess we could do it on a county by county basis, but the problems with the HOAs in Fulton County are the same problems with the HOAs in Douglas and Cobb. They all operate the same. And so I think it's really more of a statewide issue. And frankly, almost to the extent of federal issue, because you have so many different states coming with all these different laws. So I'm unaware of any other jurisdictions with a HOA court, but I believe it is the right thing to do. I think it would help cut down on the attorney's fees. I think there ought to be mediation required. Typically in Fulton County, if you go file for a divorce, the first thing they do is make you go to mediation. And so, we could adopt a similar policy here. Again, I don't think HOAs work best when we have neighbors suing neighbors, or neighbors suing the association, or the association suing the homeowners. When we took over our board, we waived all late fees and interest for 30 days and asked everyone to work out a payment plan. And when that 30 days was up, we extended it for an additional 30 days. And then when that 30 days was up, as 60 days had expired, we extended it again for another 30 days. We're just asking everyone, hey, work out some type of payment plan with us. And we were able to increase, our membership collection rate to over 90%, just by taking what I call the neighborly approach.
Exactly.
But if you let the management companies and law firms run your HOA, they're not going to necessarily take the neighborly approach with your neighbor. And so just think about that. And certainly remember that if you are on the HOA board, the management company and the attorney work for you. They should do what you tell them to do. You are their employer. And so, you may certainly want to listen to them, but you may not necessarily have to agree to take the steps that they think are necessary. You may want to consider, again, what I call the neighborly approach first.
Exactly. Yeah.
Well, thank you. I'm sorry, Mr.
No, I'm
Driscoll.
sorry. It's
Okay.
difficult to collect from your own neighbors.
Yes, indeed. Right. Well,
Mhm.
this has been truly informative to me. I really like this slide presentation. I'm going to ask for a copy for myself. But this is
Absolutely.
truly informative, the short-term rental segment here. And of course, if anyone has any additional questions or afterthoughts after the meeting, please feel free to reach out to the HO Alliance. I think their information is included in the chat. And if not, reach out to me and we'll be sure to get you connected and get those answers for you. It is now We're right on time, right at 11 o'clock to begin our next segment, which is covenant violations versus code enforcement. And I do believe Commissioner Arrington has a presentation to start there. We do have it from the city of East Point to add our city perspective, Code Officer Margaret DeBerry, who I've known for a very, very long time. And she's been a part of East Point's code enforcement for a very long time as well. So we look forward to hearing any perspective from her as well after the presentation from Mr. Driscoll and Commissioner Arrington. And as well, we will have Q&A during this segment also. So I yield now to Commissioner Arrington and Mr. Driscoll.
Thank you. And you're gonna have Shannon share the slide, or you want me to do it?
I think she got it up there already. Shannon, can you go to the next?
Okay. Sorry, I got all these screens.
So I guess in this session, what we're talking about is covenant violations versus code enforcement violation, or covenant enforcement versus code enforcement. So what is the Declaration of Protective Covenants? The Declaration of Protective Covenants is a document that's recorded with the county, again, that lists all of the restrictions on use of the land. Those restrictions run with the land. So basically what happens is I go out, I buy 20 acres of land, and I say, hey, from here on out, anyone that wants to live on this land has to abide by these rules. And then I subdivide the lots and I go sell those lots to people. When you buy that lot, it's subject to those restrictions which have been recorded with the Declaration of Protective Covenants with the county. And so that is what the Declaration of Protective Covenants is. Again, a list of rules and restrictions. And again, it varies from community to community, but it should be the starting point for you if you are in a community association for any questions that you may have. Next slide, please. The board, who is authorized to enforce the covenants? The board of the HOA, the association, is authorized to enforce the covenants. There may be a covenants committee a lot of times with volunteers from homeowners and tenants. And there may also be a management company that the board has hired to enforce the covenants. Next slide. Violation process, typically someone reports, then the covenant committee or board or association will confirm that there's a violation. Typically, they will then send a letter and track and document the violation. So you may get a letter that says, hey, you're in violation of this rule, and here's a copy, here's a picture of your home showing that it's in violation. Enforcement options, fines, attorney's fees, suspended privileges. That is the one in my subdivision that usually got most people to pay around summertime when the pool was open. Everybody wanted to go to the pool, Councilwoman Gordon, so they would pay their dues in time to go to the pool. But your voting privileges could be suspended, parking privileges, amenities can all be suspended, and even utilities in some condominium associations where the money for the utilities is being paid by the association. And a lot of times you will also find the opportunity to cure and or request a hearing. So typically if you get a fine letter, most declarations say, hey, the association has to send you a warning notice first. And so they typically, association will have to send you a warning notice before beginning to fine you. So typically, again, they send you a notice, hey, that if you don't cure this, then we're going to have to fine you. Next slide, please. Another form of enforcement for covenant violations is to file a lawsuit, maybe seeking a restraining order. Someone is, building a big blue second floor on their home. And that is not in compliance with the Declaration of Protective Covenants. So you can seek a restraining order or injunction, a temporary or permanent injunction, or a declaratory judgment against them. But I would caution you that these lawsuits are expensive. And you want to try to avoid them at all costs if you can, particularly if the HOA is suing you, because then not only do you have to go hire a lawyer, but then the association is also billing you for their lawyer. So you're wound up paying for 2 lawyers and only getting the benefit of one. And then after you file a lawsuit, you have to serve the party, and then typically they have 30 days to answer. The covenants, next slide, the covenants a lot of times are based off of the code. So a lot of the covenants sometimes will mirror what you will see in code enforcement. Code enforcement are the ordinances, statutes of the city, county, or state. But there may be a similar ordinance that says you can't have your grass higher than 2 feet. That may be in your covenants, but it also may be a code enforcement violation, just as a junk car in your yard that's inoperable may be in violation of the covenants, but it may also be a code violation. There's a list here of defense to the covenant enforcement, maybe the statute of limitations, maybe they're selectively enforcing it, maybe they waive their right to enforce this rule because they've been late, maybe they're stopped from doing it for some other reason, maybe the rule is vague and indefinite, and you may not be able to understand it, and it might need to take another stab at a new rule. A non-consenting owner, if you're part of that 1/3 that didn't vote for the rule change or the amendment to the bylaws, you may, in fact, very well have the right not to have that restriction imposed on your lot. Now, if you sell your lot, that new restriction would automatically be imposed on the new owner. And so it could be a violation also of the Fair Housing Act. Next slide, please. Other phases of litigation life cycle, we're talking about enforcement. After you file a lawsuit, after there's the answer and service and answer, then there's typically a discovery period, time to file motions, perhaps mediation, trial, and then judgment. And so those are certainly, again, other phases of the litigation life cycle. Again, it can be very expensive, i.e. $50,000 to $150,000 or more, depending on the size of the litigation. Next slide, please. All right, looks like that's.
Yeah, I think that's the last slide.
It looks like that's the last slide. So covenant enforcement, that is covenant enforcement, and I will turn it over to our code enforcement officers. I think it's Sergeant DeBerry to talk about code enforcement.
Good morning, everyone.
Good morning.
Good morning.
Okay. Yes, the city ordinances we go by. We do not go by the covenants at different subdivisions. So does anybody have a question about that?
So if I may, Officer DeBerry, You're correct in that, because I've had complaints about certain issues. I can't recall just offhand, but I know that the response from the city staff was that, that's a covenant related item that the HOA would have to address. The city cannot enforce, the city cannot enforce, the city can't enforce, the city cannot enforce covenant related items. We can only enforce violations that are within our city code. I do have a couple of questions, and I had a hand raised, Miss Brenda Floyd, I believe. Are you able to unmute and raise your question?
Now I am muted.
Okay, thank you.
Thank you. What I was trying to do was may I have copies of the last session with Commissioner Arrington? Can we have copies of some of the presentations?
Oh,
So we will make those available to Council Member Gordon so that she can distribute them. We also have them available on our website at hoaalliance.org. Again, hoaalliance.org. The way to get them on there is to get a membership. The membership started $5.99 per month. But again, it is a nonprofit. And we are, again, just homeowners helping other homeowners because some homeowners helped us.
Thank you very much for the information.
thank you. And we also had a Q&A, a question in the Q&A. I don't see it anymore. I think it was Miss Connie.
It's moved to answer.
Oh, you answered it. Okay, thank you, Mr. Driscoll.
Okay.
If there are no other questions on this segment, we also have Sergeant Bridges with us. And I wanted to say, I've attended a number of HOA meetings, and many of the communities in our city often will request presence of an officer. And that's for many reasons. And whether it's to give updates on crime or nuisance issues they may be having, but definitely want to yield to Sergeant Bridges if she has any input in terms of how those requests can be made for police presence at different community or HOA meetings to address some of the very topics that apply here, because sometimes code enforcement is involved, definitely, but there may be items within a community where the police actually have to become involved as well, especially those nuisance related items. So if Sergeant Bridges is still online, if you would like to render any comments, please feel free.
Yes, good morning, and thank you, Councilwoman Gordon. Yes, we definitely have a police representative from the police department at every neighborhood association. At least we try to. So if you do have a neighborhood association in the city of East Point, please email me. My email address is dbridges with the S, bridge with the S, at eastpointcity.org, or you can call me at 404-323-2928. So that way we can get a representative out to your neighborhood association and address your questions, concerns that you may have. And we also, if you request, we have code enforcement come out with us at your meeting, so that way they can address your questions as well, pertaining to different situations that you have coming up. So please give me a call. You go on the city website under planning and development and planning, I think is how it's worded, I'm not for sure, and drop down and you can register your neighborhood association on that site. And once you have registered that your neighborhood association, you can call me and let me know that you have registered your, and I can get that information off your site, and that way have a representative from the police department to attend your neighborhood association. And I want to thank you again. If you have any questions, concerns, please email me, call me. I'll be glad to answer your questions. And if I don't have the answer at that time, I will find the answer and get it back to you. So thank you again.
Thank you so much, Sergeant Bridges, as well as Officer DeBerry. If there are no other questions regarding code enforcement, Commissioner Arrington and Mr. Driscoll did provide a great presentation. So I definitely want to be sure that if we have any other questions, or if you have some later, we can definitely get those back to you. So I'll pause for just a moment. We are a little ahead of time for our next segment, but I don't see any other questions or concerns. Mr. Driscoll, you were helping me out there. Do you see any in the chat?
No, additional question. Me and Marvin have responded to everyone. You know, with
We just got one in, Sergeant Bridges. Yes, can you repeat the website? Or they want to know, can you place it in the chat?
Yes, I'll place it in the chat. It's the East Point City website, and you just drop down and you go under, I'll put it in the chat so that everyone can get that information, because I want to make sure that it's worded correctly so that way you can go to the exact location. But also I would put it in the chat. But thank you again.
Thank you so much, Sergeant Bridges and Officer DeBerry, for joining us today. I'll yield back to Commissioner Arrington and Mr. Driscoll if there's anything further on this particular subject matter. And if not, we have about 15 minutes before our keynote speaker. If you would like to continue to progress into that, or if we want to take a quick break or what have you, I'll yield to you for that.
All right, I mean, certainly we can,
I can add
yeah, go right ahead, Mr. Driscoll.
Okay. I think what's important here is that we're trying to convey to everyone that it's important that you understand that with anything related to your community, you start with your declaration. Anything equated to ordinances for the city, you have to make sure you work with code enforcement. Now, there may be some times where they overlap, like the height of the grass. But for more bite, I would say, leverage your code enforcement for enforcing some of the rules. And I think so in some cases, code enforcement don't deal with certain things like parking on the street. And that may be a code enforcement, unless that's different with the city of East Point. You would work with the city of East Point Police, code enforcement, and your board. But generally the board has a formalized process for submitting complaints about your neighbors. I mean, I can remember we set up a platform where we had people complaining about owls in their yard. If not our domain, but they would submit recordings of owls or pictures or poop in their yard. I don't know if code enforcement gets stuff like that, but you just have to know what to work with. I recommend everyone take some time to read at least the restrictions of the declaration, so you can avoid some of these pitfalls that Attorney Arrington spoke to earlier. I know, Councilwoman, you speak to him as commissioner. He has many hats in my book, so you'll see me bounce between Commissioner Arrington, Attorney Arrington, in some cases.
Well, I think also, I think the two can work very well together, so that, you may want to start out with covenant enforcement and reporting it to the HOA. And if you're unable to get the satisfaction that you desire, then you can perhaps then reach out to code enforcement, but you need to make sure that there is in fact something that code enforcement can in fact enforce. And then there's a violation of a city ordinance. But I think they can work well together. And if it's something that code enforcement can't do, then, you probably at that point need to go the covenant enforcement route through your association. So I think the two can work well together, and that they can complement each other in that fashion.
Yeah, well, the key is code enforcement doesn't enforce HOA rules.
Right. and the HOA can't enforce the code. And so you need to know the difference between the two. And again, the declaration is the way to find out at least what the covenant enforcements are. Your declaration is a lot shorter than the city code of ordinances. So it's probably a lot better to start there.
Well, as a layperson, for me, it's almost the same, even though that's true. But I mean, it really starts. I mean, we get a lot of calls and people have not taken time to at least peruse the declaration. And I know it uses legal language, but I mean, at least take a stab and make sure you understand what's before you. And I wish I would have read mine before I bought the house, but hey, I mean, at some point I got to know those documents. I understand the documents, and I definitely asked lots of questions, and I encourage everyone to do the same thing. All right, I tried my best to take up some more time then, Ms. Courtney.
You did well. I've been told that the keynote speaker is ready whenever we are, but I also want to add to this segment that sometimes it is a little difficult to know, who to reach out to or which route to go, but always feel free to reach out to your council member or the city manager's office if you have any conflicting ambiguities that you don't know which route to really go. I mean, quite often the HOA board will know, but even in that case, sometimes they don't. I know recently there was a situation that I was made aware of regarding, say, a broken garage door, and it looks as though it could be harmful to someone. And I believe that was a situation where both, as Commissioner Arrington said, sometimes they work in tandem together, because that door could have fallen on someone, but it's also an eyesore as well. So, if you need any assistance, it's all hands on deck here. We're all here to help to make sure that any violations like that are handled by the appropriate parties. So
frustrations are because people just don't know, and they feel like they're being bounced between resources.
Exactly, right. So please feel free to reach out to us, and we'll make sure we get you on the right path. And code enforcement is always ready to come out and take a look at what your concerns are, and they'll get you put you in the right place and get you on the right direction.
We did get one question in, Councilwoman Gordon. When selling homes, Clarissa asked, when selling homes at closing, is it required for the realtor/closing attorney to provide and review the community governing documents with the new homeowner?
That's an awesome question.
The answer to that question is no, it is not required, but you are still subject to the rules regardless. And that's one of the things that we put in our bill that Representative William Bodie sponsored, trying to have transparency for homeowners. It should be required that at least that you be provided with a copy of the declaration. I don't know that the closing attorney is necessarily in a position to advise you about your rights under the declaration, but at the very least, you should be provided a copy of that declaration at closing. Now, typically you will get a closing, because if you're buying in a community association, you typically want to get a closing letter from the association so that they can make sure that they collect all the money from the previous owner. Because if they don't collect it from the previous owner, then they're going to be coming trying to collect it from you. And so typically, along with that closing letter from the association, will be a copy of the Declaration of Protective Covenants. And, they've turned everything into a profit center now. They have it where you can buy a copy, but it is readily available in the Clerk of Superior Court and through the Superior Court Clerks Cooperative. You can go in and search for a copy of your declaration if you do not have one.
If I may add, Mr. Arrington, when I was on the board, we provided a copy of all governing documents to the closing attorney as a part of closing. And they didn't share them with the new residents in all cases. And of course, when the resident become a member of the community, they're upset because they don't have a copy of those documents. We can't explain why they don't provide them in all cases, but that would be nice to make that a part of a legislation initiative to make sure that happens. And of course, Councilwoman Gordon probably can speak to the due diligence period of the real estate process when the new residents can do their due diligence and they can request those documents. They can even request financial documents before their closing so that they can peruse those documents before closing on their homes. So I don't want to think we have to put the onus on the real estate agents. They are already managing quite a bit of the process, but I'm quite sure they are willing to help them request those documents. So if you have some kids who are out on their own, they've graduated from college and they're about to buy a new home, that would definitely be a recommendation I would make to them. Hopefully
Very good information. Okay, and we are right on time. Thank you so much. This is also so informative as well, and I'm making sure we don't have any other last questions. Doesn't seem as though we do, but again, thank you both for providing this segment and also to our city staff members for joining us this morning. And you're more than welcome to stay with us for the balance if you like. But we really do thank you for facilitating these segments with us this morning. If now we are ready, Ms. Brenda Floyd, I'm sorry. Ms. Floyd?
Yes.
Did you have another question?
Yes, I do. Okay. I have a situation where what do you call it? Investor was selling a property and they weren't given any notification that they had to pay an assessment of fees upon selling the properties. So they sued because they were not, they did a, what do you call it when you go small claims court? And they went in to, they didn't want to pay, didn't think they should have. I was trying to go into the system in I think in Superior Court to find out how the decision was made. They won, by the way. And I wanted to see the final decision that the judge issued. And I can't get anybody in Fulton County because, because of COVID, it's hard to get help sometimes. Does Commissioner Arrington, do you have any suggestions on how to communicate with the court system so we can get information sometimes?
Well, I would say that Cassandra Kirk is the Chief Magistrate Court Judge. And I'm sure that if you contacted her office, that she would be more than happy to assist you. However, there are a lot of the Fulton County court records are available online, either at the clerk's website, and I'll put that in the chat. It is, FCCOK. I think it's fultonclerk.org. I'll check that.
Excuse me, I don't have the savvy to get around the computer, but I had the case number. Okay. I did get some information. I can't get to the final decision and how it was made. And I don't have anybody that I can talk to.
I will put my email in the chat. If you email me the case number, then I'll see if I can look it up and see if I can find it for you.
Why, thank you very much. I appreciate it. Thank you.
No problem.
Thank you so much, Ms. Floyd, and we'll make sure that you get connected with Commissioner Arrington directly to obtain that information. And thank you for raising that concern. So at this time, as long as our HOA Alliance founders are okay with transitioning to the keynote speaker at this time? Are we okay with that or, okay. At this time, I would like to introduce to you Mr. Justin Miller Dubose, if I'm pronouncing correctly. And he is with the Marshall Agency of Allstate. And the topic of discussion here will be insurance. And I know that this is a very, very important topic of discussion. And we would just definitely like to, at the end of his presentation, allow you Q&A as well. So at this time, I will yield the platform to Mr. Justin Dubose.
I don't see him in here.
Yeah, I'm gonna try to see if I can track him down. I don't see him in either.
Oh, he just got it.
Hello.
He's in.
Are you there, Justin?
Yes, I'm here.
Thank
I was muted. Thank you so much. Thank you, Ms. Gordon. I would love to share my screen. I have a wonderful presentation that I'd like to share with the viewers. Just not entirely sure how to share the screen yet.
Okay, you have permission. You do have permission to share. There's a share screen button, should be at the bottom of your screen.
Okay. I do not see it yet.
No.
No.
Do you see the chat bubble at the bottom?
I do see the chat bubble. I see raise your hand and Q&A.
Oh, okay. Let's see.
Yeah, make sure he has the right to share.
Stephanie, are you sure it's,
I see.
I promoted you to panelist and perhaps you can now have access to share.
Thank you.
Okay. Perfect. And here we are. Perfect. Is everyone able to see? Can you hear me?
Yes, we can see you.
Yes.
Thank
Okay,
you.
perfect. You're welcome.
I see it.
Okay, so good afternoon, everyone, or good morning, rather. My name is Justin Dubose again, and I'm an insurance agent over at the Shana Marshall Agency. So to go ahead and get the ball rolling, I want to discuss what exactly homeowners insurance entails. Many homeowners have homeowners insurance and they're paying per month or annually and don't exactly know what that coverage entails. So I'd love to go ahead and debunk some of those myths and highlight what those coverages afford you. So moving right along here, I have what homeowners insurance actually covers. Homeowners insurance is a financial protection for anyone who owns a home. If your home is damaged or destroyed in an unexpected incident like a fire or tornado, homeowners insurance is there to help cover the cost to repair or rebuild your property. So when you have a policy declaration or at the time that your policy is bound, you have coverages that your agent goes over, and many times that goes way over the heads of most homeowners. That insurance lingo is really dense. So I'm here to just touch on the coverage type. So number one, we have the dwelling itself. That is, am I cutting off the definition here? Okay, so the dwelling itself, it pays to rebuild or repair your house and the structures attached to it. And that coverage, think garage, think the frame of the home. You can use this coverage type if your house is damaged by fire, wind, or any other covered disaster, okay? And so in the next section of your policy declarations, you'll have the highlight for your other structures coverage. What this coverage does is that it pays to repair or rebuild your shed, your guest house, any fences or other structures on the property. You can use this coverage if a structure not attached to your house is damaged by a covered disaster. Again, think carport, not garage. And so your personal property coverage here, it's in place to pay or to repair or replace furniture, electronics, kitchen appliances, etc. Think the contents within the dwelling. So you have the frame and your personal property within it. If anything happens to that personal property, this is when you'll use this coverage to file against that claim, okay? You can use this coverage, again, if your belongings are stolen or damaged by a covered loss. And so the next coverage type here is additional living expense, a more comprehensive coverage for your dwelling. It pays for hotel stays, rentals, restaurant bills, and any other temporary expenses that you may incur should your home experience a total loss or if it's uninhabitable, okay? So just to reiterate here, you can use this coverage if your home is damaged in a disaster and you are unable to live there. So the personal property, the personal liability coverage type, it pays for guest medical bills and legal expenses. So say you have a family gathering or cookout and someone has an allergy and they have to go to the hospital, you are liable because they were under your care. In this instance, you'd be able to use this coverage if you're legally responsible for someone's injury or property damage. Many people don't know that. So the next coverage type, and pardon me if I'm going fast, if there are any questions, definitely feel free to let me know. We have medical payments. And so this coverage is in place to pay for the guest medical bills that they may sustain from injuries while under your care, minor injuries, that is. All right, and so now here we'll discuss some common misconceptions. I'll go ahead and debunk some myths that homeowners typically have. I've heard these myths floating around while quoting, while prospecting, and I'm not sure where they stem from, but I'm here to debunk them. So really quickly, myth number one is that the flood damage is covered by standard homeowners insurance. That is not the case. The fact here is that home insurance doesn't cover flood damage. There is a completely separate flood insurance policy that must be purchased in order to, in addition to your standard policy, in order to be covered, okay? So myth number two is that your medical expenses are covered in case of injury. That is not true. The medical payment portion of your home insurance is designed to protect you if a guest gets hurt on your property. You and your family are not covered in case of injury on your own property. No questions? Okay, myth number three. Making an inventory list of your possessions is a waste of time. That is totally untrue. I think it's most advantageous to make a list. An inventory list is the proof of your ownership, okay? It's a fact checker. When you file a claim, you will be asked to list all of the items that were lost. To make sure that you don't forget anything and to maximize the reimbursement, I would say, and I always advise my clients to prepare a list of your possessions ahead of time, okay? Myth number four is that the premium goes up every time a claim is filed. The fact here is that that is not exactly true. A single claim may not result in a premium increase. You can, of course, discuss with your agent if you have certain policy protections against rates and claims, like a rate card. But it is always an estimate. It's always best to estimate the cost of repairs before filing the claim. You don't want to go around calling your claims department, inquiring about claims in the most minute inconvenience, because that may adversely affect you, okay? If the cost isn't much higher than your deductible, then it is more reasonable to pay for it yourself. An example here is that I had a client call in about a $1,500 estimated cost of repair was about $1,500, and they had $1,000 deductibles. And it would be most advantageous to not file a claim in that case and to just come out of pocket the additional $500, whereas you'd have to pay that anyway, the whole 500 as opposed to 15. Alrighty, so home insurance covers all valuables, including jewelry and furs. That is not the case. Home insurance, it has a limit on the amount of coverage for valuables, and they're typically in schedules. And so if particular possessions are worth more than that amount, you should purchase additional coverage for those items. Myth number 6 is that homeowners insurance covers damage caused by a lack of maintenance. That is not true. Home insurance does not cover mold or other damages caused by poor maintenance or what we consider in the insurance industry to be neglect, okay? You're responsible for the maintenance of your home. If your insurance will not cover appliances that stop working or roof replacements, it typically will not repair any damages due to aging either. Myth number 7 is that flood insurance is only for those who live in flood zones. The fact here is that floods can happen anywhere at any time, and it is not just in a flood zone. A standard homeowner's insurance policy doesn't cover damage caused by flooding. Flood insurance will keep you covered in that instance, okay? Myth number 8 is that many people believe that in order to lower your insurance premium, you have to lower your coverage. So untrue. Red flags here. If your agent says, we'll go ahead and drop your coverage, leave them alone. Reducing your insurance coverage in order to save on your premium is a bad idea outright. You should always be adequately insured. Okay, to keep your premium low, I would advise that you discuss with your agent any discounts that you're applicable for, potentially learn what options you qualify for that might lower your premium. For example, you can increase the deductible or install a burglar alarm system, which may afford you a discount, okay? Myth number 9 is that the dwelling coverage amount is based on the purchase price of your home. That is not entirely true. Your dwelling coverage should be based on the replacement cost of your home. Should you experience a total loss, what is the value of the home at that time? It doesn't need to include the land portion of your property. The replacement cost is usually calculated by multiplying the square footage of the home by current local construction costs. If you make upgrades, changes to the standard base of your home, and you enhance certain portions, of course, that would tie into the replacement cost. Myth number 10, last but not least, you cannot buy a home without buying home insurance. Not entirely true. If you have a mortgage, most lenders may require you to purchase home insurance, but it is usually up to the homeowner to get proper insurance. I have advised clients that have totally paid off homes to go ahead and insure their homes as well. I have instances where some were able to inherit property, and you don't want to run into an instance where your heirlooms are lost because you didn't adequately prepare for life to happen, okay? So that is the end of my presentation here. I will take this moment to address any questions or concerns you all may have. Here's my contact information. I'd be more than happy to discuss your policy information, your declarations and your coverages if you would so choose.
Thank you, Mr. DuBose. This was a great presentation. We do have a couple of questions that I've noted in the chat as well as in the Q&A. The first one from Ms. Judith Bowles. Is there an industry minimum coverage for an HO6 policy?
There is not an industry minimum coverage that I am aware of, no.
Okay, thank you. And then we have another question. Someone wants to know if homeowners insurance will pay for HOA fees.
No, homeowners insurance typically does not pay for HOA fees. My understanding now.
No, that is definitely correct. I have a few questions. I know that you just basically stated that, typically, yes, there is no requirement for you to purchase homeowners insurance. But what often happens, and this is something I deal with in my primary job regarding renewals for condo unit owners. They get at renewals, if they don't have proof of insurance, they are getting forced placed coverage notices. And I just wanted to state that oftentimes forced place coverage by your lender is going to be so much more in terms of cost, but it's only going to cover, I kind of say like walls out, Mr. DuBose, if I'm saying it incorrectly, it won't cover a lot of what Mr. DuBose just went over, your belongings and your items. So it is prudent to definitely consider whatever company you would like to go to, but definitely to consider having homeowners insurance at all times to, in the event that there is an incident where you experience loss, because forced place coverage is usually far more exorbitant than what you would find by getting your own policy.
That is
yourself.
absolutely correct. Absolutely correct in that the people who have an interested in, or an investment interest in the property itself, they're concerned with the structure, the home. They have no matter in your personal belongings. That is not where their investment lies. They are going to make sure that they've invested money for your home loan, that you have a house and they have a house that they can lend you until that is paid off. So if you experience a total loss and your belongings are destroyed, that is none of their concern. And so that's up to you to replace, unless you have insurance.
That is correct. I have two more questions, if I may. If no one, I'm looking to make sure I'm not going before any of our guests here. Is there one more question? I'm sorry.
Oh, I can start video.
I have a question. Can you help with E&O insurance for the board?
E&O, like evidence of insurance?
Errors and omissions.
Errors and omissions insurance for the board.
You know, we could. I'm definitely not going to bite off more than I can chew. I'd have my agency owner assist me in that, but yes.
Awesome.
Great. So my question, Mr. DuBose, you mentioned flood zone coverage and taking out flood zone policies. Would you do that? Is that, I mean, I know it's a separate type of policy because I do that on a commercial side, but I don't know carriers or, brokers on the residential side.
Right. And so I do write commercial insurance as well. And so I'm with Allstate. Of course, we have third-party companies that we write through, and we do offer flood insurance through those. Typically, our standard home insurance policies, we don't afford flood insurance, but we can also write with partners who will be able to afford that policy.
Okay, because oftentimes what I also do get from condo unit owners that are in my clients list at work is they will be forced placed flood coverage too if they live in a high risk zone. And high risk meaning that you have greater propensity for a flooding incident. And those zones are again labeled high risk, such as and you may know this, Justin, property that zones with an X or an A or AE, any designation with those zonings would definitely require the lender would require that the homeowner have that separate flood insurance policy. So oftentimes with some of these mortgages, they will let you know, and you can't even close without proof of that coverage. So
absolutely,
if you're sitting here not knowing if you're in a flood zone or not, it's easy to look up really quick and simple to determine if you're at risk. But as you stated, a flood you just never know. You never know if something's going to flood out. So I just wanted to raise that point to the fact that sometimes if you are in a flood zone, the mortgage, when you're ready to close, they're going to let you know because they're going to require that you have that coverage.
You're absolutely correct. You will have to secure that coverage, especially if it's a requirement, a prerequisite in order to close, like you said.
And one last thing, I know some people often get, when you close on a home, you have all these warranties that kind of come with the purchase of your home. But over time, is it the 5, 10, 15, you start, your warranties expire. And so then you're bombarded with all these warranty companies, like many of us are bombarded with these car warranty companies. But say, for instance, a home warranty company, you stated one of the myths, I think, where, homeowners insurance is not going to cover your refrigerator or your stove. So can you kind of speak to, why it's important to not just maybe go get an American Home Shield or one of the others versus, or in lieu of getting home insurance, a home insurance policy?
I'm sorry, can you run that last part by me one more time? The last part of the question?
Sure. No, basically I was just wanting to ask if you would just kind of reiterate the importance of home insurance versus thinking that you can get a home warranty program in lieu of having homeowners insurance. Because sometimes American Home Shield might sound as though they're going to cover everything. If you don't read carefully and understand what a home warranty program offers versus what homeowners insurance offers. Does that make sense?
Totally. And so a home warranty, to my understanding, a home warranty program, it sounds like it aids in simple, I guess, malfunctions that may take place within a certain time frame. I'd imagine your AC units and things of that nature up into a certain age of the home. Now, correct me if I'm misspeaking, that's not my forte. Whereas a home insurance policy is going to be a bit more comprehensive. Not only will it include your personal property, it also is going to help protect the dwelling itself in the case of a total loss, wherein a homeowners association policy, is that what it's called? A warranty. A warranty is not there to replace, it's more so there to aid in malfunction, is the best way to put it.
Correct. Thank you so much. Are there any additional questions? I'm looking in the Q&A as well as chat, and I don't see any hands raised. Let's see. Just making sure I don't see anything, but I do thank you, Mr. DuBose. Your presentation was very informative as well. And homeowners insurance is dire. It's something that we must have at all times. It's really important because an event, those are unpredictable and we just never know. And I'm pretty sure most people who are here online are insured, but if not, definitely consider this presentation and all of the good tips and information, as well as the debunked myths that were brought forth to us today. And I will yield to Mr. Driscoll and Commissioner Arrington.
The only thing that I wanted to mention, thank you so much, Justin, for your presentation. The only thing I wanted to add, which is, I guess, not particularly on topic, but certainly relevant, the state of Georgia has received $330 million for mortgage assistance. And it will also include the ability to pay HOA fees. And so if you are behind on your mortgage, or if you are behind on your HOA fees, you can go to georgiamortgageassistance.org. Again, the state of Georgia has $330 million available to help homeowners with their mortgage. This is similar to the eviction prevention program that they've had for the past 2 years. So they help the renters and now they're helping the homeowners.
That's good information. Can we place that in the chat as well? I'm sure I know the city of East Point has definitely put out that information, but just to reiterate, I think the website was georgiamortgageassistance.org, Commissioner?
Yes, I'm typing it in to make sure that I got the address correct.
Okay.
Sorry. Yeah, that'd be a wait.
Yeah, I didn't get it correct. I'll put the correct address in the chat box.
Okay, wonderful. This is good news. Thank you so much. And again, thank you, Mr. Justin DuBose, for this very well put together presentation today and the information. We really appreciate you being with us today on a Saturday. And
Thank you for having me.
I believe he left his contact information as well on one of the previous slides. But if you would like to get his information and you did not get it, Justin, if you don't mind, please feel free to add it to the chat. Okay. And we'll definitely make that available for those who would desire to have it.
Absolutely. Thank you so much.
You're very welcome. Thank you for joining us. So our last two topics will be facilitated by our very own Commissioner Marvin Arrington, as well as Mr. Correll Driscoll. Those two last topics include the legalities of HOAs, COAs, and POAs. And the last topic would be best practices regarding transitions. And I will yield to Commissioner Arrington for the very next segment.
Thank you, Councilwoman Gordon. Shannon, did you get the email with the presentation for this one?
Just a moment.
Thank you.
Okay, I need a few minutes to try to pull this up. I just need, I don't know if we want to maybe
Okay, no problem. I can go ahead
highlight
and
something.
start. Yeah, I can go ahead and start.
Okay.
So when you're talking about an HOA, you're talking about a homeowners association. Again, an HOA is a community association, is I guess the broader topic or broader term. HOA is one type of community association. A condo association is another type of community association. The POA, Property Owners Act, is Property Owners Association Act is another type of HOA. However, most HOAs, first and foremost, are nonprofit organizations. They are established as Georgia nonprofit corporations, and typically they are subject to the Georgia Nonprofit Corporation Code because they are a Georgia nonprofit corporation. And so they're not necessarily a 501c3, but again, they are a Georgia nonprofit corporation. So you start with corporate law, you file your articles of incorporation, you adopt bylaws. Most of your associations, in addition to the Declaration of Protective Covenants, you also have bylaws. And let me explain the difference. The bylaws govern how the company will run. So typically in the bylaws, you will see information about elections. You will see information about officers. You will see information about terms for election. And those types of things in regards to the running of the company. The Declaration of Protective Covenants runs with the land. So the Declaration of Protective Covenants deals with the land and the uses on that land and the restrictions on those uses on that land. But your bylaws and your articles of incorporation govern how the company and its officers will operate the company. Now, HOA is most subdivisions are HOAs. Basically, there's a nonprofit, Georgia Nonprofit Corporation Code, and then you apply real estate law to that Georgia Nonprofit Corporation. Well, they adopted the Condominium Act, and the Condominium Act is a separate act that governs condominiums and their use. And so the rules of that Condominium Act govern all condominiums in the state of Georgia. The POA, the Property Owners Association Act, is an attempt to bring HOAs more in line with the Condominium Act and the Condo Association. Basically, it sets up a set of rules for the HOA. However, most HOAs, again, are just HOAs, they're not POAs. POA is something new. And so what we see now are a lot of HOAs attempting to convert over to a POA, and some are successful at that. I don't necessarily know if it's good or bad. What I would say is, if you, as an individual homeowner, a POA may not necessarily be in your best interest, but if you are a board member, I do believe that the POA is in the best interest of the association. And so there may have to be a balancing act there between, particularly if you are a board member, between you and your individual rights and what's best for you versus your position as a board member, which requires you to act on behalf of the best interests of the group. Georgia Corporation, Georgia Nonprofit Corporation, most HOAs. Now, the other thing that makes an HOA, they have mandatory membership in HOAs. You are automatically a member. It doesn't matter if you don't get an invoice. It doesn't matter if you don't get a payment booklet. You are automatically responsible for the HOA fees for the year. Some HOAs allow people to pay by the month or by the quarter, but you automatically have membership, and your membership fees and dues must be paid. How we looking on that PowerPoint, Tammy?
You know, a few little difficulties, but you're doing great, sir. You're doing great.
Yeah.
I might be able to pull it up and share it from my screen. Let me see if I can do that. Yes. Let me see if I can.
I was looking to see if I could find them too.
All right, can everyone see that?
Okay, yep.
So community association documents, and I'll just recap briefly, talked about the different types of community association. Co-ops were real popular back in the 70s, but we've gotten away from those. Communities with covenants, mandatory membership. Sometimes there may be voluntary membership or voluntary mandatory hybrid. And then sometimes what we found, Councilwoman Gordon, is they're mandatory on paper, but they're defunct in reality. And so we have to deal with those things. We talked about covenants. The covenants are a contract. The covenants, the governing documents are a contract, again, between the homeowner and the associations. What are the covenants? I think we covered that. The covenants are the rules and restrictions on the land placed by the declarant. How do you find them? You can find them at the Georgia Superior Court Clerks Cooperative Authority website. Who is subject to the covenants? Anyone that is living on the land that has been declared, that the covenants have been declared on. Who can enforce them? The association can enforce those covenants. Those covenants can be changed, but it requires 2/3, typically 2/3 of all homeowners and or lot owners. And sometimes homeowners and lot owners may be different, particularly if you have a phase 2 or 3 that was never begun, but there may be 100 lots back there. And so you may have 100 homeowners, but they may have 200 lots. Who can change them? The members. The members can change them, again, by adopting an amendment to the declaration and or bylaws. How long do they last? They typically last indefinitely. And again, for the corporation, you need your articles of incorporation, your bylaws, and typically you have to do an annual renewal. There may also be different rules and regulations, again, regarding rental or other things like that. Lost my light. I can't operate without my ring light, y'all. But there may be other rules and regulations. There may be architectural guidelines. There may be board resolutions for adopting of one thing or another. Must be here. Something in here. There we go. Got my ring light back. I'm trying to glow like you, Commissioner Gordon. How to obtain your community association documents. Typically, they're in the county land records. Again, those are held by the Superior Court Clerk's office of your county. So you can go to Fulton County Clerk and get it, or you can go online. Again, I put the web address in the chat for the Georgia Superior Court Clerks Cooperative. It's gsccca.org. The Secretary of State, you can get the articles of incorporation and bylaws from the Secretary of State's website, or you can get them from your manager and or board, or as the buyer, you can request them from the seller. There are also, again, as we stated earlier, online ways. Some associations make them available for free, and some associations and management companies make them available at a cost. We talked about nonprofits, we talked about nonprofits, about the associations being Georgia nonprofit corporations. As far as community association insurance, obviously there's liability insurance for the common area properties, i.e. the clubhouse, the tennis courts, the pool, the playground, the entrance way, right? Someone, drunk drivers driving and hits the entrance way that was nice and beautiful and decorative. You need to have insurance. The association should have insurance in place in order to be able to replace those things. D&O insurance is directors and officers insurance. It also is sometimes known as E&O, errors and omissions insurance. I think it's really both of those. It is errors and omissions insurance for directors and officers. And so if you are on a board in an association, you want to make sure that the association is paying for E&O insurance for you and the other directors and officers, because in case you do something wrong, you don't want them to be able to come after your house. You want to make the association should have insurance in place to help cover that. Fidelity Insurance is another type of insurance that you need in case of theft of money by an association member. Fidelity Insurance will allow you to recover any of that money that may have been taken. Workers' compensation, depending on, if you're in a condo, you may have more than 2 or 3 people working, so you may have workers' comp insurance. A lot of subdivisions don't necessarily have that because they don't necessarily have the insurance, and obviously the flood insurance that Mr. Dubo spoke about earlier. Owner and association property, casualty insurance, responsibilities. So in a condominium association, if you're in a condo, you are responsible for everything inside of your walls. And the association is responsible for everything outside of your walls. Everything outside of your walls is common property in a condo association. The association definitely wants to maintain property and casualty insurance. You don't want anyone dying at the pool, someone drowning, and the association being sued. We had a situation in my subdivision. Young man did not drown, but he almost drowned. And the lifeguard was off duty that day, had called in sick. Association didn't know. The lifeguard company didn't provide a replacement. And the association, thank goodness, the young person did not drown, but it was a very close situation and that possibility was there. So let's see. Condominium owner and association property insurance responsibilities. What's covered, what's excluded. Are there additional optional insurance coverages? And obviously, if you're an owner, you want to maintain, as Mr. DeVoe says, you want to maintain your own home insurance as well. And so typically you'll have meetings. Again, this is typically you'll find information about the community association meetings and the bylaws, but typically there are notice requirements, quorum requirements, voting at board meetings is addressed. Typically agendas will be addressed, or who has the power and authority to create the agenda and manage the agenda. Typically, there's a requirement for minutes to be kept at the board meetings. Also a requirement to follow parliamentary procedure, typically Robert's Rules of Order. The Georgia law and typically the declaration also allow for methods for voting outside of a meeting. And then there's also typically information in the bylaws that talks about the removal and replacement of board members. There are different types of owner meetings or different types of association meetings. If it's a member meeting, then all of the members or all of the homeowners should get notice. If it is a board meeting, all of the homeowners are not necessarily required to get notice. Only the members of that board are required to get notice. Now, typically, you want to make sure that you share that information with the homeowners if you are on the board. The more transparency, the better. Typically, there's an annual meeting of the members. So typically the members will meet once a year annually. Typically at that meeting, they will adopt annual budget and have an election of officers. So again, you look to your bylaws to talk about the timing and the content of the annual meetings, the timing and content of special meetings. A special meeting can be called. The membership can force a meeting. If you have at least 10% of the members, you can call a meeting. But again, you will have to look to your bylaws and your declaration for specific terms as to what was allowed in your community association. Quorum requirements, who counts towards a quorum? Sometimes, if you haven't paid your dues, you may not be entitled to vote, or you may not be entitled to have your vote count. You can have proxies. Georgia law allows for proxies to count toward a quorum. And if no quorum, now this is what happens, right? A lot of times, Commissioner Gordon, will have people coming in and saying, well, this board has been in place forever. They won't get off the board. And every time we try to have a meeting, there's no quorum. If there's no quorum, you can't take any action. But now you need to talk about a quorum of who? At a board meeting, you only need a quorum of the board members. At the annual member meeting, you need a quorum of members in order for the board to take action at that meeting, including typically holding and hosting an election. So one of the things you may have to do, Mr. Driscoll and I in our subdivision, we walked into the meeting with 60 proxies. And then there were 60 people at the meeting, and of those 60 people at the meeting, 30 voted for us and 30 voted against us. Well, that meant we had a 90 to 30 or 75% trust of the association in the vote. So proxies from owner meetings are allowed. Electronic voting in this day and age should be allowed. I don't believe there's anything in the law that prevents electronic voting. The meeting agendas, board elections, voting in membership meetings, and voting outside of a membership meeting. And I'll stop there and see if Mr. Driscoll has anything he wants to add.
Yeah, always. In this regard, right, this is really setting the foundation for understanding the community association. And, you know, I am of the opinion that board members need to be astute and understand this information that Attorney Arrington is sharing, and he's just presented. And members of the community need to be aware of it, but I wouldn't put it as a requirement unless they plan to serve on a board. When we think about these community associations and the requirements, I think the biggest point here is that Georgia code or state code governs. And, you know, that's a great place to start when you think about the enforcement of these rules or the compliance with these rules. You know, the state take precedence all the way down to the governing documents within a community. So make sure that, you know, you take some time to peruse that information. And this is another set of information that you need to sort of be aware of before you even think about talking to an attorney or a city representative, to sort of make sure you have your head wrapped around some of this information. That's all I wanted to add, Marvin.
All right, and I don't know, Councilwoman Gordon, if we have any questions, or if anyone wants to raise their hand and has any questions about the information that was presented.
Yes, I'm looking now to determine if there are any questions or comments. I have a question as I await any others. We have a community and they have a neighborhood association, which we have several of those in the community. They're not actual HOAs. And they have years ago looked at getting or becoming an HOA and at least getting some covenants. And that just seemed to be such a tedious task. Is there, you know, because this is a neighborhood that's very nice, but is, you know, came on board before we had to have HOAs. Do you have any suggestions on how they can kind of maybe strengthen their group without well, maybe by getting covenants, or how to go about that in a more feasible way, or if becoming an HOA is the actual step they might need to take in order to kind of have the strength that I think they're looking for as a community association?
So, you know, it's difficult because, again, you're talking about asking people to give up their individual property rights and become part of a larger group. And so to some extent, I think it's easier to do that on the front end than on the back end, right? You know, when I bought my house, my ex said that was the house we were getting, and that was the house we were getting. That was it. So you really have to pay attention to these rules and regulations before you sign on, or at least understand them, right? Because you're going to be bound by them. You're going to be subject to them, and you may be subject to them being enforced against you. And certainly you don't want to have, rules forced against you if you can avoid it. There are so many different, I guess, ways to look at that, Councilwoman Gordon. But I hope that answers your question.
Yes, I know it's a challenging task to endeavor. I just didn't know if your legal mind had any other suggestions, because they've definitely looked at it from a number of angles over the years, and it's just been something that they kind of had to just put aside. But they, and I just want to take this opportunity to say that I know that there are several members of different HOAs and neighborhood associations that are with us today. And I want to thank them for the volunteer work that they do, because this is volunteer, and it's hard. It's hard work, and they keep their residents engaged and informed, and they work closely with city government to make sure that their communities are functioning properly. And I just want to say thank you to them for doing such a tremendous job within all the communities within our city, because without you, our city's neighborhoods would not be as robust and amazing as they are. And we work together to try to fix all of our issues. And I think that this HOA boot camp is a great start. This will not be the only one. This is just the first one. So we want to hear from you and just continue to keep you engaged as we go throughout, having more of this series and engaging topics that might be of more interest and concern to you as well. So I just want to thank them for showing up, and also thank you too. Again, I know this is not the end, but I just wanted to take this moment of pause to say that to you, because this is really important information. And we're glad that everyone's here today to partake in to obtain it. So thank you.
Yeah. Now, if I can add, I only know of one community that's been successful with establishing a post-community association. They out of DeKalb County. And, the voluntary membership, as Commissioner Arrington has stated, is really a challenge because we're giving up those property rights. And if anyone is similar to me, I treasure my property rights as a homeowner, but I do also understand the collective rights used to protect our interests, our collective interests. And what they've done is, when they couldn't get existing homeowners to submit to the, I'll say, restriction of the collective, they would ask them to allow the restrictions to take place when they sell their home. So when a new homeowner come into the community upon purchase, the restrictions apply. So there are a number of approaches that you can take, but it's more of like a slow crawl, like a snail, than when you buy your home initially with those restrictions baked into the plat. But it can be done, but it's going to take some diligence and some work.
Yeah, I was gonna say the old adage, the only way to eat an elephant is one bite at a time. And so I would say that they need to start small and build up as many people as they can, get as many people signed on as they can. And then, like you say, what Mr. Driscoll says is a great idea. Hey, if you won't agree to sign on now, will you agree that once you sell your property, that it will be included? And so that may be a way out for some. Hopefully, again, the intent of the HOA is to protect your property value, protect the value of your home, make sure that the community is nice, that they're not, trash cans and things hanging that would lower your value, then no eyesores in the community. So, if that vision is being followed, then, hopefully you're in a good position.
Exactly. Yeah, and I think a marketing strategy have to be implemented too. You have to sell people on the benefits. moving forward for the area. Again, you know, I've been working with Commissioner Marvin Arrington on educating people around community associations for years. And even my thoughts about community associations have moved back and forth at like a sway around this issue. So, you know, we just have to continue along the path of educating and having these discussions. And at some point, we're going to have to try to push some public policies or encourage some public policies to protect homeowner rights. And, you know, that's the biggest concern for me as an individual and for the HOA Alliance is how do we protect each and every individual that live in these community associations. And so we have to have that top-down discussion to help out. So hopefully that encouraged. I see 2 questions popped up. I know one was in there earlier, but there's
I see a hand raised, Ms. Brenda Floyd. Ms. Floyd?
I think that might have been from earlier, Commissioner.
Okay.
It's been raised for a while. But Mr. Driscoll
Yes.
is correct. Oh, I'm sorry. Ms. Floyd?
I'm sorry, I was on unmute. I had to unmute. What's your question, Commissioner Arrington?
No, I just saw that your hand was raised. I didn't know if you had a question or not.
I didn't know how to take it over, but when the 2 of you, now that when my hand's been up, I do have a question. Which one of you should we contact if we want? I know you're an attorney, and I know you're also a commissioner. But what kind of services does the gentleman that was just talking, what does he provide? What is his role?
Well, so the HOA Alliance is a nonprofit corporation that is built to help homeowners in community associations help other homeowners. And so we started this nonprofit. The services that we offer are dispute resolution, board training, and other various services for resident training, election monitoring. And so you can send an email to us at the HOA Alliance, Georgia HOA Alliance @gmail.com. And I'll put that into the chat. And if we can help you, we will certainly do whatever we can to help you, because someone helped us when we needed help. And that help may include referring you to an attorney. Certainly you are available to choose the attorney of your choice. I do have, about 20 years experience doing HOA law. So I am available for attorney consultations as well. But, depending on what your issue is, you may not need an attorney consultation. You might just need us to point you to a law on the open records request. I saw Mr. Driscoll put something in the chat earlier about the statute that allows you to request records from your HOA. Sometimes it gets difficult to obtain the records that you want from your HOA. And so there's a specific process that is outlined in the statute. And if you follow that process and the process outlined in your declaration, then you should be able to get any and or all records that you may desire.
And if I can add,
Go ahead, I'm sorry.
no, go ahead. I was just going to say that I provided a link to a template for those open books and review requests that Commissioner Arrington just spoke to. I do speak with quite a few individuals and board members in reference to how we can help. But anything dealing with legal, stick with Attorney Marvin Arrington.
Okay. Okay, and I just was wondering, getting an overview, who does, I'd rather start with Georgia HOA Alliance. the nonprofit. Because, you know, sometimes, like you said, you don't need an attorney, but sometimes you do. So I can make that assessment when I get some of the links that you're gonna put out there, but I appreciate it.
And to answer your question, Mr. Driscoll does the IT and the finance.
Okay, okay.
Yeah, muddy areas.
Okay, thank you.
So thank you, Ms. Floyd. We have another hand raised. It's Herdy Manina.
Yes. I am a condo association, and I'm actually on the board of directors. And we recently hosted our annual meeting virtually, and we allowed our ballots to be mailed into our management company for tabulation. My question is that in light of the fact that our documents state that we should host an annual meeting, and at that annual meeting, the voting should be done. Our attorneys they conferred with a couple members on our board, and he said, according to the Georgia Nonprofit Act, it allows for a meeting, for the annual meeting and tabulation of the election results be held outside of a meeting. How true is that?
There are certainly, the law definitely allows for action to be taken outside of a meeting. And I think particularly with COVID now, you know, that you would have difficulty trying to say that someone, you know, unless you can prove that someone did something nefariously, you know, allowing an online meeting and allowing ballots to be mailed in, you know, I think would be okay. But there are ways under Georgia Nonprofit Corporation Code to take action without a meeting.
Okay, but if they're mailed in, isn't there a way that, you know, they have to be stamped and recorded? And I mean, my whole thing is that our association requested that we have 2 or 3 members go up and watch that process to monitor, because I will have to say that we have some issues with as far as honesty on our board members, of our board members. So I am just, and then when we asked to review the ballots, they said that they threw them away. And our annual meeting, our votes were in October. We had our meeting in October. Also, there, in addition to that, we have a member that was elected to the board who is not even a homeowner.
Well, I think you may want to give me a call. I'll put my email and phone number in the chat, and or look at hiring an attorney to help you enforce the rules against the association. You know, I think, you know, is it reasonable that they threw them away? Maybe, depending on how soon you asked afterwards. But I think that any member or owner is allowed to view the process and can have themselves or an attorney present. And I think that maybe if you had asked to have an attorney present or had an attorney ask to be present, that you may have gotten a different response.
If I can add, if you don't mind, if you take a look at 14-2-1601 and 1602, they specify how long all those records should be maintained before they're properly disposed of. I don't like to use the word destroy because, you know, this is sort of a records management concern. And although HOAs are not as big as government and corporations, they do still have compliance requirements for maintaining those records.
Yeah, my understanding is I think they're supposed to maintain all records for 3 years.
Yeah, for the most part. I think some founding records like the Secretary of State Article of Corporations and the other documents like Declaration, they have to be maintained for the lifetime of the association. So all of those things need to be checked with Georgia Code to make sure they're in compliance. And I'll relate to some of my personal experience. Our recent board that was elected stated that the management company lost the ballots for their elections, right? Which could bring up some other challenges.
Right.
Does that mean we need to interpret that as they're not duly elected and do a do-over? I mean, in order for everyone to be on the same page, we need to make sure the compliance is met. And I think that's what Marvin was talking about. So I would definitely make sure you note his information. I think he is one of the best attorneys to speak with, because he's sensitive to not only the HOA, but individual members. So we just need to make sure things are done. And we're not perfect. Board members are not going to get it right the first time, the second time, but they need to at least put forth a considerable effort to get it right. Now, that's not the same thing we can say about our elected officials for government. But those things need to be honored. But again, from a member perspective, if you feel that you're wronged by the HOA or the community association, condo, it doesn't matter. They think your only recourse is to litigate. And again, that's costly.
Oh, I agree. Commissioner Arrington, did you put your information in the chat? Did you say?
I did, but I will do it again.
All right. I have your phone number because I think I spoke with you once before, but I just want to kind of put it, so get an email so that I can send it to you.
And you need to hold your community association accountable and responsible to follow your governing documents to the T. They're held to a higher standard based on my experience in the court system.
Right.
I don't see how Commissioner Arrington practiced law. I think it's a boring area of life sitting in those courtrooms. That's just my personal perspective.
Mm-hmm. All right. Thank you very much.
Thank you so much. We have another question from the Q&A chat. It's please reiterate D&O insurance, directors and officers insurance. We are a nonprofit association and only have liability coverage.
Ooh, dangerous.
So the first thing you need to do is contact Justin, who was just on, or insurance agent of your choice, and get errors and omissions insurance for the directors and officers. That insurance protects you in your role, protects the board and the officers in their role, so that if a mistake is made, there is insurance in place to cover that mistake, and then no one tries to come after you. Well, they may come after you personally, but at least there's money in place to satisfy that. So you do not want to serve on a board that does not have E&O insurance.
Now,
particularly, you're volunteering your time. You're volunteering your time. You may subject yourself to a lawsuit. You want to make sure that there's insurance.
Yeah, and if I can speak, add a little value on that, you need to protect yourself and your family. Because if you have litigious people in your community, get ready for the ride. I mean, this is to protect your interests. I know in the most declarations, they require liability insurance, but you need to also think about D&O for sure. I wouldn't even recommend anyone work on any board without D&O. Maybe that's a better way to put it.
The other thing that is good that Mr. Driscoll and I did, the United Way has a nonprofit board training program.
Yes.
They take you through a 13 or 16-week course that teaches you how to serve as a nonprofit board member. Yes. And so it is a great course. I think it's free, but you may have to contribute or raise money for a nonprofit in order to be a part. But it is a great training program that teaches you how to serve as a nonprofit board member. It's called the United Way VIP program. and a lady by the name of Janice Robinson runs it. It is an excellent program, and we recommend it all the time. So if you are on a board or interested in being on a board, please take advantage of this course. And then, you know, because once you learn how to be a nonprofit board member, you then just have to apply the declaration and the HOA law to that nonprofit board. Or the information that you learned from that course. You know, that's one of the other things that we have in our bill. We think people ought to, you know, as a lawyer, I'm required to have 12 continuing education hours a year. We think there ought to be training for these board members. We have homeowners that are volunteering to serve on these boards that may not have the skills necessary, but have been thrust into a position. And we think it makes sense that there be some type of training for these people.
Yeah. And Ms. Brunner, I can help. This is where I also add value. I can facilitate an introduction to Janet for the VIP training. I generally send over an email, mutually introduce you all so that you all can get started. So anybody that's interested, I'm putting information in the chat so you can reach out to me and I can facilitate that introduction. In fact, I wish this was required training for anyone interested in board service or even members that are on boards, amongst other types of training that would add value and maybe tone down some of the litigation within these communities. That was a great question, by the way.
It really was. And again, just even at work, most of our clients that have the developers that have COAs and penthouse condo associations, they actually do have the D&O, the E&O, Fidelity. They kind of try to incorporate as much as they can to provide those protections. So that was an excellent question. Thank you.
Mm-hmm.
If there are no other questions, and I don't see any others, gentlemen, please feel free to help me in case I'm missing anything, but I don't see any hands raised either. We do have another hand raised.
Okay.
Is Miss Hurdy Manina again, I think?
Yeah, I'm sorry. I really don't mean to monopolize the time. I wanted to give other people an opportunity to ask questions. I wanted to go back to workman's comp insurance. I was reviewing our insurance policy and I saw that we had workman's comp insurance. And I noticed from the slide, you said workman's comp / for volunteers. Now, in that policy, which I'm not privy to the policy at all, but I did see the fees that were associated with it. We are managed by a management company, and all the employees should be employed by the management company. So why are we required to get workman's comp insurance, or would we be required? I guess that would be my question.
If I can add some value there, sometimes you know, you may have to consider volunteers employees, although you're not paying them a salary for the work that they do. There may be time, let's say if someone climb up on a ladder to hang some Christmas lights and they fall, then you may have to provide some workman comp insurance for those people. That's why you have to make sure you're careful with what you have your volunteers do for your community association.
Okay, thank you very much.
Yes, ma'am.
And additionally, I think under Georgia law, you have to have at least, if you have at least 3 employees, you are required to get workman's comp insurance. And so the question is, does your association have at least 3 employees? You may or may not need it, but I think, you know, Mr. Driscoll is right. There may be some circumstances where a volunteer committee could possibly be considered as an employee, but I would certainly check that, sit down with a competent insurance agent and let them explain that to you. Are you on the board of your association?
I am.
If you are on the board, you should be entitled unfettered access to any and all documents.
Yes.
I agree with that, but I have been well, I'm the only one on the board that I've been on the board since 2007. But I'm the only member that wants to do the right thing. Now, let me just put it like that.
Well,
And they have been limiting my access to a lot of stuff. So I'm just
congratulations and condolences on your board.
I agree. I agree.
Yeah, well, if you look at your government
Excellent
documents,
job.
your declaration specify what type of access you have as a board member. So no one board member can limit your access. They may make it problematic for you, but you have open access as Mr. Arrington has stated.
Thank you all. Thank you.
Yes, ma'am.
I was aware of that, but sometimes it's not even worth the hassle.
Well, just look at your declaration, that secret sauce in the bylaws is right there. A lot of your answers that you would pose to other people are already answered in those documents.
Oh, I know. I've read the documents and I know them. I just have, it's a lot of our members are relatively new to the community as well as, well, our board consists mostly of investors anyway.
Okay. Yeah, so I will be concerned about my insurance designation for that community if that's the case.
I am concerned about it. That's why I'm going through these changes with them, and I put everything in writing. And so if for any reason, because I do know that the board can be sued individually as well as collectively.
Yeah,
So,
but remember, they would be protected, hopefully, if they have D&O. You know, because if you look at I know it's in our article of incorporations that board members are indemnified.
all right.
You may find that language in your article of incorporation. Most people don't read that. And again, all of them collectively together, based on what I heard in court, is that they make a single contract. And, you know, from a legal perspective, Mr. Arrington or Attorney Arrington would be the best person to talk to about that. I'm a lay person just like you. It's just that I've been dancing in the suit for a while, and life lessons continue to teach me things. So,
Yes.
you know, as a board member, I would encourage you to have these discussions with your attorney for the community because you have access to them. But I would also, you know, seek my own legal advice because, you know, and I hate to put it this way, but the ignorance of members can make your life a little bit more difficult than it should be, in my opinion.
Yes, and it has. So.
Yes, ma'am.
You usually have three options: lead, follow, or move and pack. Pack and move.
I think at our last meeting, you made that statement. So.
You would know.
Yes, I know you would.
Yeah.
Thank you.
Yes, ma'am.
No problem.
But I'll pray for you and your board service. I think board members have a more difficult experience than, you know, most of our government representatives. But, you know, I haven't been a government representative, but I've definitely been a board member.
Mm-hmm.
Yes, it's no easy task. I can only imagine.
Yes, ma'am.
So I think we have, well, it looks like we have one more question that just popped up. I'm sorry.
Yeah, we did.
The question from Connie Dennis, would you have to get a real estate attorney?
Not necessarily, but I mean, ideally you want someone that is familiar with HOAs and community associations. A real estate attorney would probably be good. I guess it depends on, you know, what your specific issue is. Your issue may be more around the operations of the company. And so you may need a corporate attorney, you know, so rather than real estate and the covenants. So it really depends on what the underlying issue is, on what type of attorney you need to get.
Okay. Thank you. And I see no other additional questions or raised hands. And so at this time, we can now transition to our last topic of the day, which is best practices for transition. And again, I will yield to our co-founders of the HOA Alliance.
Yes, ma'am.
Well, yeah, Ms. Menina kind of led us there anyway with my lead follower, get out of the way. What we did in our community, we tried to follow, and we could not follow. We did not trust the people that were in leadership. And so we decided to run for the board ourselves. Mr. Driscoll and I, we did that, and we again went door to door collecting proxies from people. We stood out in front of the HOA giving away coffee and flowers, at the entrance and the exit, all of those type of things. And then we really became the voice of information, and people trusted the information that we gave them. And so, if you can't get a quorum and you had the same old membership or same old leaders, you may have to just take it. I didn't want to run for the board. I just felt compelled to run. I felt that I could do a better job than the other people that were there. The people that we had when we took over, people that were there prior to us taking over, they basically just
Rubber stamped.
Yeah, they basically rubber stamped or did whatever the management company or the attorneys told them to do. And again, it's good to listen to advice, but I think, you don't have to just, you don't just have to let the management company and the attorney firm take over your association. And that's what we found a lot of times. The board members are volunteers, they're busy with their families, life, and work. And they just and the management companies and law firms know that, and they take advantage of that fact and just proceed when really the board is in charge. The board is in control. The board is responsible. If they do something wrong, the board is responsible. You can delegate responsibility, but you can't delegate the obligation. The obligation remains with the board. And so, the board can delegate again that responsibility to a management company or to a law firm. But if something goes wrong, the homeowners are coming back looking to the board. And again, we believe in a neighborly approach in trying to resolve any issues that may arise.
Yeah, it's a difficult job. I learned more about campaigning when I ran for the board. So, that was my first exposure to it. It's a difficult job establishing and maintaining that trust because everybody has their agenda. And so, again, I like the way Marvin put it, my congratulations and my condolences to you serving on the board. So,
Point taken, point taken.
yeah.
All right, next slide, please.
Yep.
Okay, so what is transition? Transition is described as the period when the association converts from declarant control to homeowner control. So typically in a declaration, the declarant, let's just say John Wheeland would be the declarant. He would go out, buy 30, 40 acres of land, build 200-300 homes, and declare and put a declaration of protective covenants, protective rules and restrictions over all land in that 40 acres. The declarant typically retains the right for 20 years or sometime identified in the documents to maintain declarant control. typically the declarant will have control of the board and the right to appoint members to the board. And so when you get to a point where the declarant, let's just say after 20 years, the declarant no longer has the right to appoint board members. And at that point, the board members are to be elected by the members of the association. And the declarant may surrender declarant powers if all the lots are built out. And typically it will retain declarant status until all of the lots are developed. The declarant is the only one that can change the declaration of protective covenants without a vote. The declarant can change them at any time that they want to, the declaration of protective covenants. So that is important to note. So the period, again, transition is the period when you go from declarant control to homeowner control. I had one case over in Douglas County in 2016, and the declarant's right to appoint board members expired in 2008. The declarant still had control of the board and the HOA, and we went in and immediately sent a letter demanding a homeowner election. And they had to grant it to us. They were 8 years overdue. And what happens is they sell you these homes and then they figure out a way to try to milk as much money out of you as they can for the next 30 years. And maintaining control of the board is one of the ways that they can do that. Next slide, please. The transition process. So in Fulton County, we have adopted what is called a turnover or transition ordinance. And that ordinance requires the declarant to bring all common areas up to code before transitioning to homeowner control. If you are on the board, you're a new member on the board, you want to assess all common area property because you are now responsible for the maintenance and upkeep of that common area property. And you also want to examine and review all contracts. If you're, and really, I guess there could also be transition from one homeowner board to the next, and maybe all of these things should apply to both forms of transition. But if you are a new board member, you definitely want to assess all common area property. We had a situation over in a subdivision in South Fulton, Councilmember Gordon, I think it was Councilmember Helen Willis's subdivision, and the clubhouse was sold at a sheriff's sale for non-payment of taxes. So imagine you're in a 200-300 person subdivision and you now no longer have access to your clubhouse because some board member or management company forgot to pay the taxes on the property. Well, it's important that you know all the properties, make sure that you get property tax bills paid. And if you're a board member, it is your duty, it is your obligation. You have a fiduciary duty to the association to make sure that these things are done. Next slide, please. Reserve study. One of the first things you want to do is get a reserve study. If you are on the board, you want to get a reserve study because the reserve study will tell you, it'll give you an outline for upkeep and maintenance of common areas, like the clubhouse, tennis court, parking lots. It gives you a maintenance schedule. It says, okay, in year one, paint this, paint the clubhouse. In year two, repave or stripe and line the parking lot. So it gives you a 20-year schedule for, again, the upkeep and maintenance of common areas. It tells you how much you will need each year to cover those costs. And it's conducted by a professional engineer who examines the common area properties and, provides that maintenance and replacement schedule. And it is recommended that you revisit that reserve study every 5 years. Next slide. The challenges for transition, construction, is there still ongoing construction, governance, preparation of the documents, the guidelines for governance, communications between the homeowners and the declarant, maintenance of common property by the association. So in our association, when we took over, we saw, and Mr. Driscoll did this actually, but the retention and detention ponds had not been maintained in over 15, 20 years by John Whelan. Mr. Driscoll called code enforcement, and we as an association got cited, but we were able to take that citation, send it to John Whelan's people, and we were able to get them to pay for the cleaning and maintenance of the retention and detention ponds. We had gotten a quote for like $100,000 or $120,000 to do it because it was, again, 20 years worth of growth. They were able to get it done, I think, for $30,000 or $40,000, but they bore that financial responsibility because we said, hey, we got this citation. This is 15 years, 20 years worth of growth. We can't be responsible for that. We need you to take care of that. And fortunately, they did take care of it. Financial control, budgets, litigation, insurance, engineering reports, and punch lists, all of those are some of the challenges that you will face if you are going through transition with a declarant-controlled board versus homeowner-controlled board. Next slide. Who are the parties? The board, the association, the manager, and any other approving authorities like City of East Point. These are the different parties. In our subdivision, we had a management company that we were not that pleased with, and they had a contract for 5 years, but our declaration said that contracts shouldn't last longer than a year. And so we were put in a position where we eventually fired the management company. And there was just a lot of stuff going on. A lot of these management companies will use these things as profit centers. They're using your community as a profit center. And I guess there's nothing wrong with that because we live in a capitalistic society. But, if they do it at the expense of relationships between the neighbors is when I think there's a problem. Next slide. One of the things that you may be able to do if you're in transition is you may be able to ask the declarant to enter into a tolling agreement. Tolling agreement would toll any statutes of limitations and allow you all to work out anything that may need to be worked out. I have one subdivision now. A new builder just came in and finished phase 2 and sold out all of those units, and but there are no street lights in phase 2. And it's been over a year now that we've been working with them to try to get the builder to do, the declarant to do what they need to do in order to get the street lights back there. And so again, a tolling agreement is just an opportunity to toll any statutes and limitations while the parties attempt to work out the transition. Next slide, please. So yeah, we have a sample transition agreement. If you get a membership, you can have access to that. Again, our memberships for the HOA Alliance start at $5.99 each. We've got an example list of documents to be turned over, a transition checklist, and we'll be more than happy to provide you with a copy of the Fulton County Ordinance and the Fulton County transition checklist. That is public information, so happy to provide you with copies of those. Next slide, please.
That's the last slide.
Okay. Mr. Driscoll, you have anything to add on transition?
Yeah, so the transition is one of the most confusing aspects for new board members, especially if you look at your management company contract, they're supposed to offer training, free training, or already paid for training to the new board members as a part of that agreement. And I'll say good luck on having them to honor that contract. And this may be where we can have the cities and counties help us with encouraging management companies to live up to that agreement, because there's nothing like jumping into the abyss and not having a clue about managing and operating a community. When the management company, they are the ones that's in the weeds. For the most part, they are the professionals. They go out and get certified. They have compliance requirements. They have the actual skills, and that doesn't translate well to new board members, whether it's between the declarant and the homeowners, or even between homeowner boards to other homeowner boards. I know that we've created a program, we call it more of an orientation program for members of a community so that they can be acclimated to how a community work. And one thing, and Marvin doesn't speak to it like I do in reference to talking about our personal experience as board members, because we took on the role of the management company and manage each and every service directly for our community. So there's nothing like participating in a transition directly versus going out and hiring another management company, having the original management company transition to the new management company if you really want to learn more about your craft. The transition ordinance that was passed by Fulton County, I wish we could see that in every other county throughout Georgia, because it would add some compliance requirements for the declarant to ensure that they provide you with the records, provide you with the contracts, provide you with any other reserve studies, good luck on that part, to make sure that your collective interests are protected. Because at the end of the day, that's what it's all about. You are investors in your community that do not receive any type of revenue. All you want is a good quality of life, and you want your property values to hold. And of course, there's an expectation for it to increase. But take a good look at this area to make sure you understand how your community function, what makes it function, and understand from a tax perspective, why are we considered to be a not-for-profit or nonprofit organization, right? We don't pay taxes on the dues that are received as a community, but maybe like we have a clubhouse that we could rent out. IRS would expect you to pay taxes on those collected rental fees. And just those simple things will make your life a lot easier, right? I talked to a community on yesterday where they say they've been through a bankruptcy. I mean, that's tough as a member of a community, because when I ride around my common area, I expect for it to look nice, to be presentable. I expect for the clubhouse to be in good working order. And most importantly, I want to have open access to it. These things, you know, you need to sort of, you don't have to do everything as an individual, right? Collectively come together, and some people dive into different aspects that are important to your community. I know all the time we hear finances, finance. Somebody taking some money, they gotta be taking money. I mean, some of those types of things, you want to solidify the facts. That's one thing I can say I've learned from working with Attorney Arrington, Commissioner Arrington. You have to wrap your head around the legal aspect, the compliance aspect from government, and make sure you clearly understand it. And a transition process can open your eyes to some of those things. So I think that's all I want to say, Marvin. I know I can be wordy. That's why I've been keeping the mouth shut for the most part. So hopefully everybody's getting what they need out of this. But this is the most confusing aspect for members of a community, especially new board members.
You may want to, Mr. Driscoll mentioned, you may want to actually, file taxes for your HOA. When we got in, we found out they had not filed any taxes for the HOA, and we got in and filed it for the years that we were there. But just because John Whelan hadn't done it, we didn't want any repercussions or any pushback because we weren't doing it. So we hired a CPA, made sure that we got our tax returns filed for the association every year.
Yeah, I think we had to do it for several years when we first got on the board. And, that's to protect the collective interest. I mean, just like you talked about, someone would have drowned in the pool. I mean, or a kid get hurt on the playground. If there's a litigation and there's a lawsuit that's lost, guess who have to shore paying that back? All the members of the community. So there's a collective interest there. I can truly say that I am, just like I do in IT, when I have to go out and get certified, I'm an expert in that particular category of technology. I can truly say that I am an expert in running and managing a community association because we actually did it. We didn't go out and hire a management company to do it for us. We did it. We set up the services for our help desk. We took care of collections. We got into policy writing, all of those different things. There's about 20 different services that I don't have time to run through right now that are provided as a part of your association. And maybe for the next boot camp, we can go through that. I just want to make sure that people don't gloss over this area. This is one of the most important aspects. All of it's important, but this is one of the most important aspects of living a quality life in a community and managing and operating, of course.
And we do have also an HOA handbook that we put together that is 4 or 5 volumes of everything we've collected over the last 10 years.
I'm glad you mentioned it.
It is available on our website at hoaalliance.org.
It's included in the membership too. They get it as part of the membership.
And it's included with the membership if you get the membership. So please consider getting the membership to the HOA Alliance, and please consider helping us help other homeowners.
And it includes examples. Like I put one example on a blog with the open books and review requests. And I hear a number of questions or concerns around that. Look, take a look at the examples, use them. And if you're a board member, this definitely helps out because it's all about operating and managing or some aspects of it. And there's a legal section that speaks to case law that you referenced, Marvin, as a part of your presentation. Folks, it's there. We've taken time to reduce it all to text to make sure that we can offer some value to not only just board members, but members of a community. And, you know, we don't have a lot of that information out readily available. And it's called the HOA Handbook. And I'll provide you with a link to it if you need be. All right, thank you.
Thank you both so much. I wanted to add something that happened in my own community. Of course, my community is well over 15 years old. And so the transition happened a long time ago. But there has been ongoing construction because, as Commissioner stated, there might be another phase of development, or there just might be some sporadic lots that have been undeveloped for quite some time. And so, especially during COVID, we experienced folks coming in to develop that didn't even have permits. So I just wanted to note that in the city of East Point, we do have an infill ordinance. And within that ordinance, there is a public participation component that is required so that HOAs and communities are protected or have some protections in input upon what the new development is going to look like. My HOA definitely actually has an architectural review board component within itself, so that all of those things can be considered before someone goes and constructs, you know, a home that looks nothing like or has no synergy with the community, the existing community. So I wanted to just bring that up because when that happened, our staff, and Director Smith may be gone now, but we just kind of wanted to make sure that our staff was making certain that when folks come in, that they're adhering to the infill ordinance that the city has in place, because it's really important. And that just triggered me to remind you, because having input is required by the city for within certain parameters. And I can provide that ordinance to anyone who's interested. Is the infill ordinance underneath our city code. I don't have the code number right now. But I just wanted to let that be known, because sometimes there is a long period of time between the transition period and where we may be in real time. So I just wanted to bring that up as well, because it has been a recurring issue within the last year and a half for a number of our residents in East Point. Thank you. And we do have a couple of questions. The first question: is the county responsible for the upkeep of the streets in a condo association? The county versus the city, I think, is the question.
Yeah, so I think the answer to that question is no. I think the city may be responsible. It depends on if you have a gate up. If you have a gate up, then the association is responsible for the upkeep and maintenance of those streets, because by putting up a gate, you make it a private road. And so if there is no gate, then the city should be responsible. The county only is responsible in unincorporated areas. And as of now, the only unincorporated area left in Fulton County is a small strip of about 0.7 acres on Fulton Industrial, 0.7 miles on Fulton Industrial Boulevard. So the county does not have the responsibility. The city may, if there is no gate restricting the road.
I'm sorry, I was muted. So we have another question. Mr. Driscoll, are you responding to that one? I think it has you typing, but if not, I can read it aloud if you like.
You can still read it aloud. I'm trying to make sure I understand, because it refers to a past board.
Okay, so the question Ms. Tracy Bonner has is, what are you all doing differently than the past board? How is your method more effective?
Okay.
We are not currently on the board, but in the first 6 months that we took over, we saved $100,000 and put it into a reserve account for upkeep and maintenance of the association. We had our attorney, the management company and attorney spent $4,000 or $5,000 collecting, I think $70 or trying to collect $70
Small
from,
amounts of money.
from a lady that was in bankruptcy. Well, I don't think it makes sense to spend $4,000 to collect $70 from a lady that's in bankruptcy that no longer lives at the association. A lot of these law firms will take these cases on a contingency basis. So if you can get a law firm to collect your money on a contingency basis, then why would you be paying $4,000 or $5,000 a month or more for the attorney, paying the attorney by the hour to collect on that money? Maybe John Whelan would do that, but we as homeowners couldn't afford that. John Whelan, I guess, could afford it. He was making enough money off of selling homes.
Yeah, we're mindful of the expenses
Yes.
for our community. In some instances, we found that we were paying for other communities under the management company for some of their services. So the light bill from across, 2 or 3 light bills from across the street, from a subdivision across the street, we have actually been paying for. Right. So, we were more mindful of how everything impacted the residents. So that's the value of having a homeowner board, or it should be, right? Sometimes you have homeowner boards that get themselves more aligned with the professionals and feeding their fees, and I think attorney fees are best example. Anytime, a resident owes about $200 in fines, they think that it's just the $200, and before they turn their head around, they end up owing thousands of dollars in legal fees. I think we ran it more effectively. I mean, of course, with each board administration, they can probably identify some things that we didn't take a close look at. And I'll be honest with you, being the initial board for our community, we were very busy, again, because we were doing all of the management ourselves. And, there could have been some times we overlooked something like street signs. My wife bring this up to me today. We just maintained the street signs that we had. They were wooded. They were nicely decorated. And I know my wife was like, well, maybe we should change the street signs. So the new board, they changed the street signs to the metal portion. There could be some things that come up, but we look for residents to submit those recommendations to our help desk, and we would take a look at it. And sometimes we would ask that they take the lead on things. Now, what I found with some of our members is that they are okay with throwing out recommendations, but they don't want to work and participate to help take care of the things. So just know that, we have a set of board members, probably 4 or 5 of them, they're limited in resources or things that would take their attention. So hopefully that answers your question. Every iteration gets better, but if we have more members participating, making those recommendations, maybe picking up some of those things in a committee that we would form to take care of the community, things would be great in my opinion. I just don't believe we should leave it subject to the professional management companies, because their bottom line is all about revenue. Everything they do is revenue. I remember, talking to a management company to mail out a single letter, it totaled about $20. Well, when we did it, our services, we use an online mailing services, and it was pennies on the dollars, and we save money in that regard. So, you just have to pay attention to the details. And I always tell members, don't attack your board members. Sit down and see if you can have a talk with them. Now, if they are not open to having discussions, they're ignoring you, then I can understand, but let's not get hostile. Let's just find a collaborative way to make things happen in the community. I'm done. I don't want to be wordy.
Thank you so much for that. We have another question. Does having a gate for the condo make it private property?
Ooh. I'll let you handle that, Mr.
I don't know that it makes, having a gate does not make it private property. I think what you're referencing is maybe the streets that we were just talking about. So if there's a gate, then that leads up to the condo association, then I believe the condo association will be responsible for the upkeep and maintenance of the road in between the gate and the condo association.
So I guess that means it depends.
Thank you. And we have Ms. Brenda Floyd, her hand is raised.
Ms. Floyd, we can't hear you. You might be on mute.
You were right again. Sorry. I've observed over time, because I lived in the South Fulton area a number of years.
Okay.
Why is it that people who are homeowners, who have invested money in property, don't participate as, you know, not only board members, but just residents, and to find out what's going on surrounding them? Because we lose a lot of property for many reasons, you know, finances, not taxes. And most of the time, if we would go to meetings or participate in activities like this, some of that can be circumvented. What do you all recommend for us to get residents to become engaged in their surroundings?
I think that's an age-old problem. We can go through politics and see the same behavior. Marvin, I'll stand down and let you offer your advice on that.
Now, I expected you to come up with one thing, okay?
Okay.
I'm teasing, but it's hard, but go ahead, Commissioner.
I say drown them in information, but I mean, that's counterproductive at times too, so.
Repeat the question for me, please.
How can we get the people that are not participating to engage in activities pertaining to their investments, their homes?
So I think you have to engage in increasing the community spirit. And I think that takes a round of activities like cookouts, fish fries, events at the pool, potluck dinners. I think you just have to engage the community, it goes back to what Mr. Driscoll said. People will come up with ideas, but then aren't willing to follow up on them. It goes back to the old 80-20 rule. So then you have 20% of the people doing all the work and 80% of the people taking advantage of it. But you have to do what you can. I think we did a great job of increasing community spirit. I think one of the ways we did that was by waiving late fees and interest and asking people just to pay their membership fees and setting up payment plans and things that were not done before. We allow people to make payments online, all type of different things. And the thing is, the management company pays about 3 or 4 bills. Well, we put those bills on auto pay. The power bill, the gas bill, the water bill, all of that was on auto pay with the bank. So there wasn't really a lot left to do. We had the yard man going around to make sure that there was covenant enforcement and taking pictures. So there wasn't really a lot left for us to do. Well, there was a lot left to be done, but the financial management side was kind of taken care of by automatic bill pay with the bank.
Okay. Well, thank you, because Commissioner, I think the very first thing you said was having activities to bring people together. I think that's key. Thank you.
No problem.
Yes, ma'am. Yeah, community attitude has to be promoted if you want to get people happy and engaged. In my opinion, we did a number of gatherings to bring people together. It encouraged neighbors to get to know neighbors that were not immediately adjacent to their home. It takes some work. I'm even leaning on the side of hiring a marketing team to help get that done because it's not an easy task.
Thank you.
Right.
Thank you, Ms. Floyd. That was a great question and point to
Yes, it
raise.
was. Mhm.
I'm looking again to make sure we don't have any final questions or hands raised. I don't see any. So at this time, I'll render my closing remarks and then I'll yield to our HOA Alliance founders. I again thank them for being with us today, facilitating this boot camp, but above all, as I said before, for allowing it to happen on a city level. And Commissioner Arrington said yes, and I was like, thank God, because I thought it was really important because we have very, very engaged community associations here in East Point. And this is exactly the type of activity or event that I think will help us become more knowledgeable of things that we didn't even realize that we needed to know about. And I took many notes today and I thank you for that. I thank your team for helping facilitate this. I thank all of the East Point staff members who even behind the scenes made this event possible and for making it a virtual format. We do look to have it in person as soon as we can. And again, this was just a very, very knowledgeable wealth of knowledge format today. And I really enjoyed sitting here getting all of this information. And we will again make that those slides and presentations available to those who are of interest. And at this time, I will allow the gentleman to close us out.
Well, thank you so much, Councilwoman Gordon, for hosting us today, hosting this event, and for your leadership and vision in bringing this event to the city of East Point. It's great to work with you and your staff and to see the information and presentation on short-term rentals that you all already have prepared. You guys are cutting edge. The city of Atlanta has also passed something in regards to short-term rentals, but not every city in Georgia has done this, so you all are leading the way in that regard, and that's what it takes. Communication. I know you all have been engaged with the community, and so we're just humbled to be in a position, again, to try to help others because others helped us.
Right, and if I may close out, again, my name is Karel Driscoll. I want to encourage everyone to join us as members so that we can push or encourage some legislation that further protects our rights as members of these communities, and join us as members to encourage others to join as members so that we can speak with a collective voice with our representation, not only in the local cities and counties, but also at the state level. And thank you all for yielding some of your time today. And I look forward to us meeting again for additional education. Thank you.
Absolutely. Thank you. And please, everyone, have a great balance of your day and weekend. And we look forward to seeing you hopefully at another boot camp very soon.
And for more information, visit our website at hoaalliance.org. Thank you, Councilwoman Gordon. Thank you, City of East Point. Thank you, everyone, for helping us pull this together. Channing Parham, Jarrell, Sharon on my team. Thank you all.
Yes, indeed. Thank you. Have a good evening. Good afternoon, rather. Thank you.
Good afternoon. Thank you.
Enjoy your day. Be safe.
Bye-bye.
Bye-bye.